Okay, we are now live and on the record for Wednesday morning civil docket, October 6th, 2021. And I'll start with quick announcements. And Mr. Ramirez, Ruben Ramirez.
Good morning, Your Honor. Ruben R. Ramirez. This is number 43 on your docket. Opposing counsel is David Solis, and I did see him here.
Okay, CL 23089-I, Montrell Rand et al. Versus Ofelia Luna. And what is the announcement?
Yes, good morning, Your Honor. Ruben R. Ramirez on behalf of the defendant, Ms. Luna. Just wanted to announce that that we are still considering a mediator's proposal. We did mediate in August, late August. We were able to successfully settle one of the claimants, and so we're still working on the second one, but that's the latest on there.
Okay, Mr. Solis, anything to add? Mr. Solis? I saw him come on too. I don't know what happened. Okay. And how much time are you requesting for your next status hearing?
Is David not on, Your Honor? I saw him on.
I saw him on too. Hold on. Ms. Ramirez and Ms. Tony Ramirez, I need for you to keep yourself on mute, please. It keeps unmuting.
Yes, ma'am.
Your Honor, I guess at this point, oh, there is David. His audio is trying to connect.
Oh, his audio is not connected.
David, if you want to call my cell phone, we can maybe do it that way.
If his audio is not connected, he can't hear you. Oh,
he can't? Okay.
Do you want me to temporarily excuse you and have you contact them?
Is opposing counsel Padilla on here? I do have another hearing, status conference hearing on that.
Okay.
Yes, Your Honor.
Okay. Number 41 on the court's docket.
Okay, CL 22941-I, Cynthia Maria Garcia versus Daniel Ramos.
All right. Ruben R. Ramirez on behalf of the defendant, Mr. Daniel Ramos. So at this point, Your Honor, we have some discovery still ongoing. We have taken the deposition of the defendant, and we are pending some DWQs. So we still need to conduct mediation, hopefully in a few months. And after that, pending mediation, I imagine opposing counsel will or will not want to take the deposition of my client if it doesn't settle.
Okay, Ms. Padilla, anything to add?
I did want to correct something for the record. I think Mr. Ramirez did correct himself at the end, but that plaintiff's deposition has been taken. However, defendant has not.
Correct.
Okay. So then what time frame are you looking at for the mediation?
It all depends on the records, Your Honor. I mean, if I imagine that they should be done within 90 days, you know how those records go sometimes. And then after that, once we have that, then we should have the information we need for the carrier to be able to make an assessment, a value assessment. So I'm hoping to mediate within 90 days, 90 to 120 days.
Okay. Okay, come back on February the 9th.
Okay.
At 9:30.
Roger that. Okay. That concludes my business with this matter, Your Honor.
Okay, so did you want to contact Mr. Solis?
Yes, Your Honor, if the court will allow me to be excused temporarily.
Sure, just let me know. He still hasn't been able to connect to audio.
Okay, thank you.
All right, Ms. Padilla, did you have another case?
Your Honor, I do have two other cases, but I need to verify whether or not the defense attorney is here.
Okay.
Your Honor, this is Aisa Garza. I am number 35 with Ms. Padilla.
Okay.
And that is CL-19277-I. Aisa Garza for the defendant Perla Herrera. And we've actually come to a settlement agreement on this case, Your Honor, but the plaintiff's counsel, as I understand, needs some more time to, I guess, negotiate medical records as well. We have a property damage issue. And so, you know, we're good. So we need some time to kind of figure out the details. And so I think just so we don't take up more of the court's time, if we can get maybe a 3-month status conference as our next setting, but we should be able to resolve all issues prior to then.
Okay, so then you think you'll need 90 days to finish up the settlement?
No, I think it'll be before then. I guess, well, I'll let Ms. Padilla speak to that, but my understanding is we'll need more of that. I just, I mean, and I don't mind coming back, but we don't have any issues that I believe we're going to need the court to intervene on.
Okay, because what we can do is if Ms. Padilla can give me a time frame as to how much time she needs in order for you all to conclude with the settlement documents, I can just set a tickler instead of having y'all come back. Ms. Padilla, do you know more or less how much time you need?
You know, to be safe, I would go ahead and say 90 days, you know, just so we're not constantly before the court before we're quite ready.
No,
So
well,
90 days.
to do a settlement agreement, you'll need 90 days?
No, Your Honor, because while that is something that we are still needing signed, we are also waiting on some reductions as well as
Oh,
trying to sort out a property damage issue.
okay. Well, then I guess what I'll do is I'll just go ahead and set a status for December 6th then.
Okay, thank you, Your Honor.
Thank you, Your Honor.
Okay. Anything
Honor.
else?
Your Honor, David Solis's audio is now working.
Okay, hold on. Anything else, Ms. Padilla, on this one?
No, Your Honor.
Ms. Garza?
No, Your Honor.
Okay. And do you have another case, Ms. Garza?
No, I don't, Your Honor. May I be excused?
Yes, ma'am, you certainly may.
Thank you.
Okay, give me one moment, Ms. Padilla. Okay, Mr. Ramirez, I'll recall that case with Mr. Solis, CL 203089-I. Mr. Solis, can you hear us now?
I can hear you fine, Your Honor. I apologize about that.
That's okay. All right, so Mr. Ramirez was letting us know that they're still contemplating, or you all are still I guess the parties
We
are
are.
still contemplating, or they are, the mediator's proposal.
That's correct. There was two parties. One person has already signed. There's one person left. That last individual is who is the subject of the mediator's proposal.
Okay, so how much time are y'all needing?
I believe the deadline to respond is
October 15th.
October 15th, Your Honor.
Okay. So then do you want to come back for a status in November?
That's fine by me, Judge.
That's fine, Your Honor.
Okay. Come back on November 15th
Okay.
at 9:30.
November 15th at 9:30.
All right. Thank you, Your Honor. That concludes my business with this honorable court. May I be excused?
Yes, you may.
All right. Thank you.
This is also, Your Honor.
You only have one case, Mr. Solis, today.
As far as I'm aware, that's it. Yes, ma'am.
All defense counsel is scared of him. They settle, Your Honor. Don't you know that?
Don't know about that.
Okay.
All right. Thank you.
Thank you, Judge.
All right, y'all have a good one.
You too.
Okay, Ms. Padilla, what other case did you have?
I have number 20 on the court's docket.
Okay. CL 202529-I, Oscar Estrada versus City of McAllen, and is defense counsel on?
Yes, Your Honor, Austin Stevenson for the city of McAllen.
Okay, and what is the announcement?
Your Honor, today's hearing is because we filed a motion for leave to serve 1801 affidavits on defendant City of McAllen. The original affidavit deadline ran back in July, or no, I apologize.
I can
Ran
save plaintiff counsel time, Your Honor, just by saying we're not opposed. We could do this by agreement.
Okay.
It's just one provider and we're more than happy to accept the service of the affidavits, which is allowed without court intervention. So Ms. Padilla, please feel free to serve us and Your Honor, we're not opposed.
All right. That sounds good.
Make it easy for everyone.
All right,
Agreed.
so then I'll go ahead. So what's the next step in your case then?
Just as more
I-
discovery, Your Honor. We need to take some depositions. We've exchanged written discovery and now we need to get into the deposition stage.
Okay, so then how much time do y'all need before you can give me a good status?
I'd say about 60 days, Your Honor.
Okay. December the 8th.
Okay,
at 9:30.
thank you, Your
Okay.
Honor.
Anything else,
Thank you,
Ms.
Your Honor.
Padilla?
No, that's it, Your Honor. May I please be excused?
Yes, and Mr. Stevenson, do you have anything else?
No, Your Honor, may be excused.
Yes.
Thank you.
Okay. All right, Mr. Willie McCallum. You're on mute, Mr. McCallum.
I'm sorry. Good morning, Your Honor. I have number 28 on your docket, CL 21-3183I, Yan Yin Aboites versus State Farm. Yesterday, late in the afternoon, I filed a Rule 11 with Sarah Cowan. I wasn't sure if we needed to be here, but I just wanted to let the court know that this is a case that's an appraisal, and we're just asking for 45 days to see if we can let the appraisers see if they can work this one out.
Okay, on Rule 11s, if they're filed without an order resetting hearing, they won't be accepted. So you'll have to file an order resetting hearing with your Rule 11s, and
Okay.
then we'll go ahead and accept them. So if you want 45 days out, let me see. The earliest would be December 6th,
That's perfect, Your Honor.
okay? And that'll be at 9:30,
Thank you, Your Honor. And
okay?
that's all I have before this honorable court, Your Honor. May I be excused?
You certainly may.
Thank you, Judge. Have a good day.
You too. Attorney Tim Davis?
Judge, good morning. I'm here on number 5 on your docket. It's a default divorce with no children.
Okay, F 2165-21-9 in the matter of the marriage of Jesus Villasan versus Maria Victoria Villasan. And is your client on?
Yes, ma'am, he is on. He will need an interpreter though, and prove it up.
Okay. Mr. Villasan? Ms. Castaneda, can you please ask him to unmute himself?
Jesús Díaz-San, por favor, prende su bocina.
There you go.
Okay, just make sure that you go slow in the in what you're putting on the record, Mr. Davis, so that my translator can translate it to him. Let me go
Yes,
ahead
ma'am.
and swear him in. Mr. Villasan, please raise your right hand.
Mr. Díaz-San, por favor, levante su mano derecha.
Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Jura
Sí.
que el testimonio que...
Tell him that he needs to wait until you interpret.
Mr. Díaz-San, tiene que esperar hasta que yo interprete.
Oh, está bien, sí.
Okay, yes.
All right, does he swear?
Jura que el testimonio que está a punto de dar es la verdad, toda la verdad y nada más que la verdad.
Sí.
Yes.
Okay, he can lower his hand.
¿Puede bajar su mano?
You can go ahead. Mr. Davis, proceed.
Thank you, Judge. Mr. Villasan, you filed this petition for divorce versus your wife, Maria Villasan. And prior to filing the petition, you had lived in the state of Texas for at least 6 months and Hidalgo County for at least 90 days, correct?
Mr. Díaz-San, usted metió esta petición del divorcio contra la señora María Díaz-San y para esto usted ya vivía, era domiciliario de Texas por los precedentes 6 meses y residente del condado por los precedentes 90 días. ¿Correcto?
Sí.
Yes.
Okay. And you and your wife were married in 1987 and y'all have been separated since 2001, correct?
Y usted y su esposa se casaron en el 1987 y se separaron desde el 2001, ¿correcto?
Sí.
Yes.
And there are no children under the age of 18 that were born of the marriage, correct?
Y no hay niños menores de 18 años de este matrimonio, ¿correcto?
No.
No.
Okay. With regard to the marital estate, you're asking the court to award you all the property that is in your possession or control and to award your wife all the property that is in her possession or control, correct?
Y tocante a sus propiedades, usted está pidiéndole a la corte que le dé las cosas personales que están en su posesión y la señora las cosas personales que están en su posesión, ¿correcto?
Sí.
Yes.
And there is no real estate that is owned by you and your wife, correct?
Y no hay bienes y raíces que tienen ustedes en sus posesiones, ¿correcto?
¿Cómo que no?
Bienes y
No,
raíces, no tienen propiedades en sus posesiones.
no.
No.
And with regards to any debts that you and your wife may have, you're asking the court to assign any debts in your name are going to remain with you, and any debts in your wife's name are going to remain with her.
Y tocante a las deudas, lo que esté en su nombre se va a quedar con usted y lo que esté en nombre de ella se va a quedar con ella, ¿correcto?
Sí,
Yes.
And you're asking the court to grant a divorce, correct?
Y usted le está pidiendo a esta corte que le conceda el divorcio, ¿correcto?
sí.
Yes.
And Judge, I would just ask that the court take judicial knowledge of the documents in the court's file that reflect that the respondent in the case has been served and her answer date is passed and she never did file an answer.
Okay, the court will take judicial notice of the documents in the court's file. How long have they been separated?
Judge, since 2001, so I guess about 20 years.
Okay. The court will grant the relief as requested and testified to on the record, which will be set forth in further detail in a divorce decree. Mr. Davis, how much time do you need to submit that?
Judge, actually, we just e-filed it, so it should be on its way to you.
Okay, then I'll ask for that to be forwarded to my queue.
Thank
Okay,
you.
so the divorce is granted.
Thank you, Judge. That's all I have. May I be excused?
You certainly may. Ms. Castañeda, please let him know that he's also excused.
Mr. Villazán, ya se puede retirar.
Gracias.
Thank you.
All right, Attorney Graciela Orellana.
Good morning, Your Honor. I have two on your docket this morning.
Okay,
The first one is number 45.
CL 210305-I, Edna May Signs et al. Versus State Farm Insurance.
And I believe Mr. Mark Hanna is on already.
Yes, Your Honor. Mark Hanna here for State Farm.
Okay, and what is the announcement?
Your Honor, on this one, we do have deposition set up for, or plaintiff's deposition set up for October 19th in the afternoon, and we have mediation set up as well for November 19th in the afternoon with Mr. Daniel Hernandez.
Okay. So go ahead and come back on December 6th then. At 9:30.
Thank you, Your Honor. This is the only case I have. May I be excused?
You certainly may.
Thank you.
Okay, and your next case, Ms. Orellana?
Judge, the next one is number 39, CL-20-2188-I. Opposing counsel Rosemary Conrad Sandoval did advise that she has a hearing in federal court. I don't see her on, so if you can just recall this case when she logs on, I'd greatly appreciate it.
I had let her in. I don't know if she's on now. Hold on.
Yes, Your Honor.
Ms. Sandoval, can you hear us? Okay.
Yes, I just arrived. Thanks.
Okay. CL 20-2188-I, Jeronimo Flores versus City of Alamo.
Your Honor, on this one, it's both a status hearing and there's also a defendant's plea to the jurisdiction. I don't know if you want to recall it since this is not a quick announcement.
Okay, Ms. Sandoval, do you want to add anything else?
Yes, Your Honor, with regard to the plea to the jurisdiction will be a somewhat of an argument.
Okay, then I will recall you at 11 o'clock when we start with the contested civil.
Okay, Judge.
Okay. All right. Thank you, Your Honor.
Thank
You can
you.
log back in or you can stay on, whatever you want.
All right. Thank you.
Thank you.
All right. Okay, Attorney Armando Guerra.
Yes, Your Honor, we're here on number 1 on your docket.
Good morning, Judge. Jose Hernandez here on behalf of the plaintiffs.
I'm going to
Okay,
get on behalf of the defendant, Judge.
CL 20-0176-I, Juan Martinez versus Fernando Campos. Okay, and what is the announcement?
Judge, the announcement is, I guess if Mr. Guerrero will allow, we settled the case, Judge, already. We're just preparing the settlement agreement, and we should have probably the motion to dismiss the case or file a non-suit with you within the next 30 days.
Okay. Then what I'll do is I'll just set a tickler for November the 12th to make sure that it's been done.
Sure, Judge.
Okay, anything else?
I have nothing further, Judge. Can I be excused?
Nothing further,
Yes.
Judge Moby, excuse.
Yes,
Thank
you
you.
certainly may. Thank you.
Thank you, Judge. Be safe.
Likewise. Attorney Paloma Barrero?
Good morning, Judge. I have number 8 on the court civil docket.
Okay, F 3438-21-9 in the matter of the marriage of Maria Vargas versus Ernesto Vargas.
Yes, Judge Paloma Barrero on behalf of respondent Ernesto Vargas.
Good
And
morning. Good morning, Your Honor.
Yeah.
Frank Ed on behalf of the petitioner, Maria Isabel Vargas.
Good morning. Okay,
Your Honor, this is an agreed to divorce. I believe that the petitioner is present and ready to prove up her divorce.
And Judge, if I may, all parties signed, and I did file the signed final decree yesterday.
okay. And all the parties signed off on it?
Yes,
Yes.
Your Honor.
Okay, so is Ms. Vargas present to prove up?
She should be, Your Honor. Someone in my office was letting me know that she was having trouble seeing me, but I think she is there.
Yes, I'm here.
Okay, perfect.
Okay, Ms. Vargas, please raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you may lower your hand. Mr. Guerra, you may proceed.
Thank you, Your Honor. Ms. Vargas, could you please state your name for the record?
Maria Isabel Vargas.
And you are the petitioner in this case in cause number F 3438-21-9 in the matter of the marriage of Maria Isabel Vargas and Ernesto Vargas III, and in the interest of Ernesto Vargas IV, a child. Is that correct?
Yes.
You've been living in the state of Texas for 6 months and in the county of Hidalgo for 60 days. Is that right?
Yes.
You were married to Mr. Vargas on or about September 8th of 2000, and you stopped living together as husband and wife on July 3rd of this year. Is that right?
Yes.
Has your marriage become insupportable because of discord or conflict of personalities between you and the respondent that destroys the legitimate ends of the marriage relationship and prevents any reasonable expectation of reconciliation?
Yes.
That's correct, right?
Yes.
Okay. And you have come to an agreement as far as the parenting plan, the conservatorship, child support, and the one piece of property that you own together with your husband. Is that right?
Yes.
Are you asking the court for a name change?
Yes.
Okay, what are you asking the court to change your name to?
Salazar, Maria Isabel Salazar.
Okay, I don't believe that was on the submitted decree, so we're gonna have to add that on. That's all the questions I have of this witness. I pass the witness.
Okay, Ms. Barrero, do you have any questions of Ms. Vargas?
No, Judge, no questions. I just like to ask Mr. Vargas 3 questions.
Okay, is Mr. Vargas on?
Yes, Judge, he should be. He's under Ernesto Vargas.
Mr. Vargas, can you hear us? He's not connected to audio.
Then Judge, he signed the divorce decree, so I don't have questions for him, Judge. He's in agreement with the divorce decree that we submitted. And we're not
Okay.
opposed to the name change.
All right, and did you put on the child support and what's happening with that?
There's no child support, Judge, or medical or dental support that is being requested.
Okay, so what's going to happen to the support of the children? Do you have something in that decree that makes them both responsible for the financial well-being of the children?
Yes, Judge, I believe so.
Yes, Judge, that's what's been agreed to. That's their understanding, and it's in the decree.
Okay, and what is that? You need to put that on the record. Is he responsible? What is the responsibility? Because child support is something that's required by law, unless you're going to put on the record something that he or she, they're both going to be dividing what school, clothes, shoes, school supplies. How is the financial well-being of these children going to be addressed? What did you all put in that decree?
Judge, when the children are with Mr. Vargas, he will be supporting them financially, providing clothes, providing school supplies, as well as Ms. Vargas when she has custody of the children.
Okay, and what is the visitation schedule?
It's the standard, Judge.
So then she's gonna have them the majority of the time, so then the financial responsibility is gonna land majority on her?
Yes, Judge.
And your client has agreed to that, Mr. Guerra?
Yes, Your Honor, that's what she has wanted. There was a piece of property that was very important to her. And for the time being, she thinks that it's a fair exchange, that she takes on that responsibility of caring for the child. She understands that she believes that the respondent will be doing his part. He always has. And that is what she is requesting of the court.
All right, and you've made her aware that she's not gonna be able to come back for about 3 years to ask if she changes her mind, if he does not end up owning up to his part of his obligation?
Your Honor, and if I could ask her that on the record.
You may.
Ms. Vargas, were you listening to what the judge was explaining?
Yes.
And you understand that
Yes.
you will not have that right? Okay,
Yes.
Thank you.
Okay. Not that, just so you know, Ms. Vargas, it's always in the best interest for the children to have a set financial support. So are you asking the court today to approve the agreement that you and your husband have entered into?
Yes.
Okay. The court will go ahead and grant the agreement as testified to on the record, will grant her name change to Salazar. And before I let you go, how are the children being covered on health insurance?
Ms. Vargas, how is the child being taken care of right now with their health care?
He has CHIP.
Okay, so she's gonna continue him on chips.
Yes.
Okay. All right. Then I'm gonna have to reject that divorce decree so that you all can add the name change.
Yes, Your
Okay,
Honor, we'll do that.
and then you'll have to have them re-sign if it changes the page numbers.
Yes, Judge, we'll do that.
Thank you, Judge. Yes.
Thank you. May we be dismissed?
Yes, you certainly may.
Thank you so much.
Okay, Attorney Douglas Hearn.
Good morning, Judge. Chris Sanchez on behalf of the plaintiff Mireya Alanis Flores. I'm co-counsels with Douglas Ahern. I believe he's in an immigration telephonic hearing.
Okay, and what number is that on the court's docket, sir?
That is number 18 on the court's docket.
Good morning, Your Honor. Eduardo Moya on behalf of Edinburgh Regional Medical Center.
Okay, that's CL 196366-I, Mireya Flores versus Edinburgh Regional Medical Center. Okay,
Judge,
and what is the announcement?
Judge, we're here on plaintiff's motion to refer to mediation. We filed this motion since a petition has been on file since December 2nd, 2019, which it's almost been 2 years. Since then, opposing counsel had filed a motion for summary judgment. A hearing was held and that motion was denied. Substantial written discovery has been completed on both sides. Numerous depositions, depositions by written questions, oral depositions via Zoom have been conducted on both sides, including a corporate rep deposition, the deposition of the security guard. Opposing counsel has taken the plaintiff's deposition and also taken the deposition of the plaintiff's daughter, who was a witness to the incident. So being that all of this discovery and these depositions have been completed, we're urging this motion because we believe that right now is the right time. It's the appropriate time to order the parties to mediation with a good, strong mediator, Judge. Somebody like a Gil Perales or Daniel Hernandez, or maybe even Bill Garza, somebody that's very familiar with personal injury cases. We believe that this case could probably get settled. And being that the court's docket is flooded right now with civil cases, we just feel that this is the appropriate time to order the parties to mediation.
Your Honor.
Go ahead.
Although extensive discovery has been conducted, we believe that the matter is not right for mediation, specifically because experts have not been designated and expert discovery has not been completed. Once expert discovery has been completed, a more accurate evaluation on liabilities and damages will be achieved. We think at that time a more fruitful mediation, a more successful mediation would occur at that time. Again, however, we are at the mercy of the court, and should the court order a mediation, the order would be followed.
Okay, and let's say that, how much time are you thinking that you're going to need to be ready on your side to mediate this?
Your Honor, once we have designated the experts and deposed plaintiffs' experts, at this time, the plaintiffs have retained none retained treating experts. We would like to depose them first, then designate our experts, and then proceed to depositions of our liability experts and medical experts. I guess as far as time would go, it would really just depend on when those none retained experts would be available for deposition.
Okay, well, mediation is going to occur. So, because that's the protocol of this court. And I do want for both sides to be prepared in order to do a good faith mediation. So, I mean, I'm going to set a deadline to see if you all are ready to mediate this within the next 90 days, okay?
Okay.
You are just so I can fully understand, is that 90-day deadline to revisit mediation, or does mediation need to be completed by those 90 days?
No, mediation needs to be completed within those 90 days. So do what you can to get it done within those 90 days. If you're not ready with your experts for whatever reason, or you haven't done any of that type of discovery with respect to your experts, then I expect that you all will be in communication with one another, extend some courtesies so that you all can get it done in a good faith manner. I'm not going to force you to mediate it in 90 days if you haven't been able to complete, let's just say, your expert, the expert depositions or the designations. However, waiting until the 89th day to do it is not something in good faith.
Understood.
Okay.
Yes,
so
Your Honor.
I'm going to have y'all come back on February the 9th, and I will be sending out an order of referral to mediate this by the end of the day.
Thank you, Your Honor. That's all I have. May I be excused?
Yes, you may.
Thank you.
Thank you, Your Honor, as well. May I be excused as well?
Yes, you certainly may.
You have a good day.
Thank you, likewise. Okay, Attorney Lucy Williamson.
Good morning, Your Honor. I have 3 cases with you this morning. The first one is on your docket number 12.
Okay, that's A 0073-21-9 in the interest of a minor child.
That is correct, Your Honor. I am asking today, this is on my motion for substitute service, Your Honor. We have an unknown father in this case, and we'll need to serve him by publication.
Okay. And also you'll need to check with the Vital Statistics Bureau to see if there was an acknowledgement of paternity.
Your Honor, we have, and there is not, and we will have that on file. We also have the original birth certificate indicating blank.
But they already gave you that letter? So they gave you that letter that stated that there was no acknowledgement of paternity on file?
No, Your Honor, we will be getting that and we will be filing it with the court.
Okay, perfect. That's the letter that takes forever.
Yes. Yes.
Okay. Okay, then I did read your motion and that will be granted.
Your Honor, I don't know if the court at this time would consider appointing an ad litem for this unknown father or after service.
No, you'll just file an order appointing the ad litem and then I'll appoint it.
Yes, Your Honor. Thank you very, very much. And my clients are present for the record, Your Honor.
Okay.
Your Honor, I'll talk to you later. Your Honor, I also have number 50 on your docket.
Okay, F2859-17-9 in the matter of the marriage of Sandra Cantu and Jose Hernandez.
Good morning, Your Honor. Stella Olivares for Jose Hernandez.
Good morning. Okay, and what is the announcement?
Your Honor, Lucy Williamson here for Ms. Sandra Hernandez Cantu, and she is here present at my office.
And so is my client on the screen, Your Honor. It's set for a status, Judge. It is a case that's been pending for quite a while for various reasons. I suggested mediation because it is a difficult case since we have another felony case that is kind of connected to this case, to the divorce too. So I'm asking for mediation.
Your Honor, and my client, like I said, is here in my office. Our only concern, Your Honor, is the finances. We've already mediated this case once for the temporary orders. Nothing has changed since that time. Ms. Olivares is correct. There's a felony pending against the respondent in this case, so not against my client. So what we're asking, I think this is going to be a case that's going to need to be tried, Your Honor.
Okay, who did you all mediate for temporary orders?
Mediated it with...
I don't even remember that we mediated, Judge.
Yeah, we did. Let's see.
It's been 3 years. I do not recall. Maybe informally, me and Ms. Williamson probably took care of it because it was very tough.
I was just, let's see. We even have a mediated settlement agreement back October of 2017, and the mediation was with, and it's not signed by anyone. I do not recall who the mediation was with you, Your Honor.
I didn't think.
Your Honor, if I may, I see a note that the mediator was Mr. Juan Zamora.
Oh, yes. Now I remember that you say Juan Zamora. Yes, it was. I do not, it was just for temporary orders and it was visitation, that was all. And of course, she's primary, which we have no dispute on that.
Okay, so what is in dispute?
Your Honor,
just property, Judge, and visitation.
Visitation, custody is in dispute. My client is asking
No,
for
custody is not in dispute.
Well, on the temporary, there is sole managing conservatorship unless if they're willing to give up the request for joint, for us, it needs to be sole managing conservatorship, and that all visitation
the designation of, okay, let me clear myself. Custody, to want full custody for my client to be primary is not in dispute. She can be primary. Joint managing conservator is in dispute. If you want to be sole, we don't agree to that. It's already been 3 years. He's visiting the kids back and forth. They're having a wonderful time. He's a good father. So the allegations that were made to him, he's innocent until proven guilty. So that case is pending.
Okay, so what
And it's not
we're
against
gonna,
his children.
all
I'm
right.
sorry, Judge.
Okay, so then, right now, since it has been pending for quite a while, do you all have everything that you need in order to go to, like, to start finalizing the case?
Yes, Your Honor.
Okay. So then, and if you do go to trial, will this be a jury trial or a bench trial?
Bench trial, Your Honor.
Bench.
Okay. So then this is what we'll do. Let me set you up for a DCC for the bench trial. The deadlines will be there, including for a final mediation. And then we can keep the case moving.
Yes, Your Honor.
Okay, Ms. Rivera, can you give me a date for a DCC, please?
Yes, Judge, it can be next Friday, which is October the 15th at 10 o'clock.
Okay, so let's do a DCC next Friday, October 15th at 10 a.m. And then that way you'll do your DCO and we can have all the deadlines on there.
Thank you, Your Honor.
Okay. Your Honor, I do have another case.
Yeah,
After Ms. Williamson.
Right.
completes
I have,
her-
I have one more, Your Honor.
Okay, go ahead.
And it's number 30 on your docket. And the parties should be present. The respondent, Antonio Contreras, is pro se, and my client is also on Zoom, Brianna Medina.
Okay, that's number 30. That's F7172-15-9 in the interest of a minor child. I'm sorry. Okay, you said who is supposed to be present on the other side?
Antonio Contreras is the respondent, Your Honor, and he is pro se.
Okay, Mr. Contreras, do you hear me? Antonio Contreras. I don't have anybody on by that name.
Your Honor, my client is also present. We just want to set up for a final hearing, Your Honor. It's just an issue of visitation.
Okay, so will this be a contested final?
Most likely not, Your Honor. There might be some issues, but it won't be a full day trial.
Okay, so then, how much time are you requesting?
2 hours at the most, Your Honor.
No, but how many days for the final? I mean, like how far out for the final?
30 days, Your Honor, is more than enough.
Okay. So we'll do November 10th at 11 a.m.
November 10th at 11 a.m.
Yes.
Thank you, Your Honor. Well, that concludes my business with this honorable court. If I could be dismissed.
Okay.
Thank you, Your Honor.
Thank you. Okay. Ms. Olivares, what other case did you have?
Number 11, Your Honor.
F5593-18-9 in the matter of the marriage of Crystal Alfaro and Jose Tapia.
Yes, Your
Julia-
Honor, fellow Olivares for Crystal.
Julia Hernandez for the Office of the Attorney General.
Raul Acevedo for Jose Israel Tapia Vera, Your Honor.
And that's the
Okay.
third defendant. Your Honor, we have an announcement. My client yesterday called me very distraught that her uncle had passed away. So I sent a Rule 11 to Mr. Acevedo. He signed, Ms. Julia Hernandez signed, I signed, but we didn't get it back from Mr. Jackson. So I don't know if he signed. As of
I believe that
yesterday,
Mr. Jackson. I believe that Mr. Jackson said you could sign with his permission.
Oh, I'm sorry. I didn't get that message. I did sign for you with permission. Your Honor, so that means that our Rule 11 is there because of the death in the family of my client. But Mr. Acevedo and I have already worked out our side, and only Mr. Jackson and I would be the one. So at a short hearing, Judge, maybe 30 minutes, whenever the court has time to finalize this case.
Okay, so then the hearing that would take place next would be for final. You have everything that you need to go forward?
Yes, we do, Your Honor, with Mr. Jackson.
Okay, and have you all attended mediation?
On this one, I don't believe so, Judge. I don't recall. No, we
Oh.
have not mediated because we did try to work it out several times.
Okay, so
No, we
Mr.
did not.
Acevedo, which is your client, sir?
Jose Israel Tapia Vera, he's not the divorcee, Your Honor. He's not the person who's going to be divorced. He's just another defendant, a third
Party?
defendant.
Third
Yes.
party defendant.
Okay, and Mr. Jackson's client is who?
Jose Adriel
The
Tapia Vera.
respondent.
the
Oh,
respondent.
okay, so then the middle names are what are different.
That is correct, Your Honor.
They're brothers, Judge.
All right. Okay, what I'm gonna do is I'm gonna send out an order of referral of mediation for final by the end of the day.
Yes, Your Honor.
And then I'm gonna have y'all mediate that within the next 30 days. And then I'll have you come back. Let me see. We'll do November the 15th at 11 a.m. just in case it stays contested.
Yes, Your Honor.
Yes, Your Honor. And if I may, Your Honor, I believe that we have an agreement with Ms. Olivares' client, Your Honor. Or is my client required to be part of that mediation?
No, as long as you have that agreement in a form of writing before, I mean, if you want to put it forth in a Rule 11 prior to, the only parties that need to be attending mediation are those that have outstanding issues to be settled.
Yes, Your Honor.
Yes, and that's
Sure.
correct, Your Honor. We should finalize, Mr. Acevedo and I, hopefully this week.
Okay, so do you have any other case, Ms. Olivares?
No, thank you, Your Honor.
Okay, thank you, ma'am. Mr. Acevedo, do you have another case?
No, Your Honor. And if we're not able to work things out, which I anticipate that we will, I will go forward with the final hearing as well on the day that you announced.
Okay. All right, thank you.
Thank you. May I be excused, Your Honor?
Thank you, Your Honor. Have a good day.
Likewise.
Stay safe, Your Honor.
Likewise. Attorney Victor Rodriguez?
Yes, Your Honor. Good morning. I have 3 cases, very quick announcements, Judge. The first one is number 25 on your docket. It's Escalante versus Clear Blue, I think. This is our motion.
CL 212663-I, Victor Escalante et al. Versus Clear Blue Insurance Company.
This is our motion to compel mediation, Judge. Typical standard statutory mediation, motion to compel mediation that we follow in all these cases. Mr. Rodriguez is counsel. Mr. Joseph Rodriguez is counsel for Clear Blue.
Morning, Your Honor.
That he had another hearing that he may be. There he is.
I'm on now.
He's on. This is our standard motion, Judge. Statutory. The courts are required to order mediation. The only thing I think that Mr. Rodriguez needs is some time to do maybe some initial discovery, and typically within 90 days, we're able to get everything done, including the mediation.
Your Honor, for the record, I just can't agree to the mediation, but can vouch for Mr. Rodriguez indicating that we have mediated probably over a dozen of these, been successful. And if it doesn't settle, we could come back and if we need to ask for appraisal or something like that. But, just for the record, I just can't agree to it.
Okay, the court will grant plaintiff's motion to compel mediation, and I'll send out an order of referral by the end of the day. And it'll be mediated within 90 days, and you'll come back on February the 9th.
Your Honor, we typically are able to agree to Daniel Hernandez as the mediator. Would that be okay with the court?
Yes. And you go ahead and just mediate it with Mr. Hernandez then.
Thank you so much.
Thank you, Your Honor.
But your deadline will be within 90 days, okay?
Thank you so much, Your Honor.
Yes, ma'am. Have a good day.
Thank you, Mr. Rodriguez. You have a good day. Okay, Mr. Victor Rodriguez, which is your next case?
Number 44, Judge. Sanchez versus Allstate.
Judge Randall Gomez here on behalf of Allstate.
Okay, that's CL 210274-I. Okay, and what's the announcement, gentlemen?
It's a status conference, Judge. We're set for mediation with Daniel Hernandez on October 20th.
Okay. And what about, so I'm taking a discovery is substantially complete?
We've done initial written discovery and depositions, Judge.
Okay.
And, these 95% of these settle at mediation. So if we need, we'll advise the court immediately after the mediation if it didn't settle and whether we need a trial setting. I don't see that. I see that very unlikely. But
Okay, I'm gonna go ahead and set a status for November the 10th then. And that's shortly after the mediation date, and that'll be at 9:30.
okay. And then the next and last one, Judge, is number 46.
CL 210959-I.
Yes, Your Honor. Victor Rodriguez here for plaintiff.
And again, Randall Gomez here on behalf of the defendant.
Same announcement, Judge, with this, except the mediation is set for October 14th.
Okay, then I'll give you the same date of November the 10th at 9:30.
Sounds great. Thank you so much, Judge. That's all I have.
Maybe excused.
Yes, gentlemen, you may be excused. Thank you. Okay, Attorney Pete Espinosa.
Good morning, Judge. Peter Espinosa on, I believe, number 52 on the docket.
Judge, it's 51 on your docket, Your Honor. Abel Hinojosa.
Okay, F 3808-18-9.
Judge Peter Espinosa for Blanca Gomez. We had a mediation. We did come to an agreement on all issues except one. And the mediation agreement was submitted to the court. I think Mr. Hinojosa and I can draft a temporary or an order reflecting the mediation. Now, we do have a pending motion to clarify that just was filed this morning. And that motion is to clarify the divorce decree that was entered on between the parties. And it's just one issue we're going to ask the court to clarify.
Okay, so then the motion to clarify the divorce decree will take care of the one issue that was not settled at mediation.
Well, I'm assuming, Judge, basically, forgive me, Abel Hinojosa for Mr. Guillen, Your Honor. Of course, I'm going to challenge that motion to clarify, which just filed this morning. I understand Mr. Espinosa's argument, but I mean, the mediation agreement as to my modification, I'll prepare an order as to the mediation agreement, and whatever information that Mr. Espinosa needs to get the quadro done, we'll provide. That was the agreement at the mediation. This motion to clarify is something new, Judge, and once it's set, I'll address it with the court and with Mr. Espinosa.
Okay, was an order setting hearing filed with the motion to clarify?
Yes, Judge.
Okay, then we'll go ahead and get it set as soon as it's forwarded to us. And then we can take it up at that time. But whatever issues were settled on that mediated settlement agreement, I expect that would be put into writing as soon as possible.
Yes, Judge.
All right. Well, then as far as this is concerned, then how much time do y'all need to get that order done?
Judge, I just need basically by next week, I should have a proposed order, sent it to Mr. Espinosa for his approval, Judge.
Okay, I'm gonna just set a tickler for October the 29th.
Yes, ma'am.
And then we'll get that motion to clarify set, and then we'll take you up at that time.
Thank you, Judge.
Okay, anything else?
Nothing further, Judge. Just for the record, my client is present.
Okay, that's fine.
Thank you, Judge.
All right. Thank you, gentlemen. Have a good day.
Thank you.
Bye.
Okay, Attorney Kennedy Salinas.
Good morning, Your Honor. I have number 53 of your docket, F 5397-19-9, Your Honor. I spoke with Mr. Sergio Munoz this morning. He wanted me also to just go ahead and make the announcement for both of us, Your Honor. We did have a mediation with Iberia Science. It did not go well at all. Respondent is very, very far. All there is in this case is there's all the kids are already emancipated. It's just community property issues, Your Honor. So we're asking this court is gonna probably go to a trial where I cannot say if he wants a bench or a jury. The other thing is temporary orders, Your Honor, have been done have been signed or been done at all for the community property, Your Honor. So we're asking this court, I guess, what do you want to go forward with DCC or just another hearing so we can try to?
Okay, so then the community, there are no temporary orders in this case right now?
We had done, but the judge never signed it. We were in county court number 2, I believe, Your Honor, is never signed. And it was based on the fact that we're gonna go in mediation, but basically we've just been since way before COVID, Your Honor. And there's substantial, I mean, the parties have about like 18 or 16 rental units, a house. And there are several also bank accounts also, Your Honor. And I have sent also Mr. Munoz also, so an inventory and appraisal of everything, because basically she's in control of everything right now.
Okay, so, I mean, if you all are gonna want a temporary, so then, but those temporary orders that were filed, they were based on a mediated settlement agreement?
No, they were just based because basically my client and they're older. He's fine. He basically wants to revert everything back to the children, but he just at this point he thinks that, and he is. I told Mr. Munoz is 50-50 right now. He's trying to say that there's some fraud. How's there fraud if she controls everything? So I have not seen anything of that. So we're asking that basically if this is going to proceed to a trial, it's going to be quite a while from now. So I think that basically we should have temporary orders to divide the community estate right now, Your Honor.
Okay, well, if you want temporary orders, then, of course, I'd suggest that you file your motion for temporary orders and we can have a contested hearing on it. If it's just with respect to property, since you already attempted mediation. Now, as far as a DCC, I'll only give a DCC setting if it will be for a bench trial. So discuss that with Mr. Munoz and you can let us know.
Yes, I understand that.
We can do that. But if you file your motion for temporary orders, and I'll go ahead and set it at a time when I can give some time to that case, and you just let me know how much time you all are thinking that you're going to take.
Okay, Your Honor.
And then I'll let you all know for real property issues like that. For me, the easiest format, I'll give you an easy format so that you can lay it all out for me prior to the hearing. And then it's very easy for me to divide community property, so.
Okay, and I have sent him, and we've been cordial, Mr. Munoz, and my client too, with his wife. I sent him the appraisal and for him to send me back the appraisal inventory of all the properties. And so hopefully he'll get this back, because I think you're gonna need that before we have this hearing, and then it'll help you too. So when we go to trial, basically you have everything ready for that, Your Honor. Okay.
Yes. Okay, so then how much, okay, so are you going to be filing a motion for temporary orders hearing?
Yes, I'll go follow. Yes, I will, Your Honor.
Okay, then instead of setting you for a status, and I'm gonna set a tickler for that for October the 22nd to make sure that's been filed before then.
Okay. Okay, thank you.
And then we'll go ahead and set you up at a time when, do you know more or less how much time you'll need to designate for that hearing?
No, Your Honor, I think I should be ready to go ahead and send in that motion probably this week, Your Honor.
No, how much time do you need designated for that hearing though? Do you think it'll be an hour, 2 hours?
There's several property, probably 2 hours, Your Honor.
Okay. And that way my court coordinator knows so that she can designate a date and time that would accommodate at least a 2-hour hearing.
Okay, I appreciate that, Your Honor.
All right, then we'll be on the lookout for that.
Okay, thank you. Hey, Your Honor, I have a question. If we do a jury trial, or Mr. Munoz asks, or his client asks for a jury trial, we're thinking of jury trials will not happen probably till summer, you're thinking, or?
In my court, yes.
Okay.
Or jury trials will not occur in my court until I get into the new courthouse, because I don't even have a courtroom right now.
Okay.
Unfortunately.
Okay.
So it won't be until I can get into the new courthouse. So I have no idea when that's going to be.
Okay. Understand.
Bench trials, we borrow a courtroom and we can get that done.
Okay. All right. Thank you. I'll talk to Mr. Munoz. Thank you so much.
All right.
Okay. Thank you.
All right.
May I have excuse?
Yes, you may.
Thank you.
Okay. Okay. Attorney Sarah Willingham Flores.
Good morning, Your Honor. Sarah Flores on behalf of Michael Eric Castillo. I'm sorry, we're number 49 on the court's docket.
Okay.
F
And that is
2783219. And we
Yes,
have an agreement for final.
Okay, great.
Yes.
Okay, will you be proving it up with your client?
Yes, and Mr. Edelmiro Arredondo is also online with his client as well.
Okay. All right, so Mr. Michael Castillo and Miss Leslie Robles.
Yes.
Can you all announce yourself?
I'm here, Your Honor. I'm here as well.
Okay, so let me have you both raise your right hand. Mr. Castillo, I'm gonna need for you to unmute yourself.
Yes, ma'am.
All right, do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God, Miss Robles?
Yes, ma'am.
And Mr. Castillo?
Yes, ma'am.
All right, just lower your hand. Okay, listen to the questions carefully and try to answer as clearly as possible, okay? All right, Ms. Flores, you may proceed.
Yes, Your Honor, and I would ask that the court take judicial notice of all documents in the court's file.
Yes, the court will take judicial notice of all the documents in the court's file.
Thank you. Mr. Castillo, can you please state your full name for the record?
Michael Eric Castillo.
Mr. Castillo, are you currently married to Leslie Veronica Robles?
Yes, I am.
And Mr. Castillo, have you been residing in the state of Texas for the preceding 6 months and the county for 90 days?
Yes, ma'am.
Mr. Castillo, you and Ms. Robles were married on or about November 16th of 2019?
September 16th.
September 16th of 2019. And you're both the parents of Elena Castillo?
Yes, ma'am. Eliana.
I'm sorry, Eliana Castillo. And her date of birth is 8/28 of 2019?
Yes, ma'am.
Okay. Mr. Castillo, you and Ms. Robles attended a mediation last week and we were able to finalize your case for today. Is that correct?
Yes, ma'am.
I'm going to read some of the terms of the mediation agreement today. And please, well, let me read some of the terms of the mediation agreement today. The parties have agreed that you will be joint managing conservators of your daughter. Is that correct?
Yes, ma'am.
Ms. Robles will be named the primary parent in this case. Is that correct?
Yes, ma'am.
And there is a geographic restriction to Hidalgo County. Is that your understanding?
Yes, ma'am.
Now, as for the visitation, yourself and Ms. Castillo agreed to a modified 50-50. Well, you agreed to begin the months of October, November, and December, that you'll do an extended visitation plan, which will be every Thursday night and first, third, and fifth week, alternating weekends, I'm sorry, through Monday morning. And then commencing January 1st, you'll be having visitation with your daughter, basically the AB plan, which is Wednesday and Thursday overnights and alternating weekends. Is that correct?
Yes, ma'am.
You also made a few changes to the summer visitation. Every June, you'll have possession of your child and she'll have the second and fourth weekends. And every July, she'll have possession of your daughter and you'll have the second and fourth weekends. Is that your understanding?
Yes, ma'am.
All other holidays are as per the family code, except for November. You all made one modification that you'll split Thanksgiving break every year. Is that correct?
That's correct. Yes, ma'am.
You also made agreements that neither party, due to the visitation arrangement, that neither party will pay child support to the other. And that mom will provide the medical, dental, and vision insurance, and you will reimburse her 50% of the cost for your daughter. Is that correct?
Yes, ma'am.
You all also agreed on a first right of refusal if one parent can't be with the other child for more than 18 hours. Is that correct?
Yes, ma'am.
Since there's no child support, you both agreed to 50% of the child's expenses, be it, tutoring, summer camps, types of expenses that you may incur outside of your normal household type of expenses. Is that correct?
Yes, ma'am.
As far as real property, you both don't own any real property, and the mediation agreement details who's going to be keeping, for example, the dining set and the living room set and of some of the TVs. Is that correct?
That's correct. Yes, ma'am.
Each one of you will be keeping your retirement plans, your respective retirement plans and your respective vehicles. Is that correct?
Yes, ma'am.
And each party will pay the debt in their own names.
Yes, ma'am.
You're currently still, or at the time of the mediation, you were both living in the same apartment, and there's an agreement that by November 1st, you will vacate the apartment. Is that your understanding?
Yes, ma'am.
For the month of October, you're both going to continue paying 50% of all expenses for the apartment and the utilities. And come November 1st, she'll be responsible for all those debts associated to the apartment. Is that your understanding?
Yes, ma'am.
I believe that I've covered most of the mediated settlement agreement, and I'm in the process of preparing the final decree to circulate amongst the parties. I have no further questions for Mr. Castillo. Do you believe that this mediated settlement agreement is in the best interest and a just and right division?
Absolutely. Yes, ma'am.
And you're asking this court for a divorce today?
Yes, ma'am.
I have nothing further of this witness, Your Honor. I pass
Okay,
the witness.
Mr. Arredondo, do you have any questions of Mr. Castillo?
No questions regarding Mr. Castillo, Judge, but I do have some questions for my client.
Okay, go ahead.
Okay, good morning, Ms. Robles. Did you hear opposing counsel's questions and Mr. Castillo's responses?
Yes, sir.
Yes. Did you understand the questions that were asked to Mr. Castillo?
Yes, I did.
Are you in agreement with all of his responses?
Yes.
Okay, Ms. Robles, as part of your agreement, you and Mr. Castillo entered into an agreement concerning your children and division of property. Is that correct?
Yes.
And do you believe that the provisions regarding your child are in the best interest of Eliana?
Yes, sir.
And do you believe that the division of community property is fair and equitable?
Yes, sir.
Okay, and you're also asking this honorable court for a divorce this morning, correct?
Yes, I am.
No further questions, Judge.
No further questions, Judge.
How old is the child?
2.
Okay. So the court will accept the agreement as testified into the record and will be set forth in further detail in a divorce decree to be signed off by all the parties and the attorneys. How much time are y'all needing to submit that to the court?
Your Honor, I will have it to Mr. Arredondo probably by Friday. I'm almost done with it. And then if he needs maybe a week to review it and get it signed,
That works.
you should have it within the
Okay.
next 10 days, I would say.
Let me set a tickler for October the 22nd
Yes.
for submission. And that way, I don't lose track of it.
Yes, sir.
Okay, best of luck to you, Mr. Castillo and Ms. Robles.
Thank you. May I be dismissed?
Yes, you may. Mr. Arredondo, do you have any other case?
That's all I have. Judge. May me and my client be excused?
Yes, y'all may be excused.
Okay, Your Honor, have yourself a great day.
Thank you, Your Honor.
Okay, sorry, I needed a water break. Okay, Attorney Liliana Elizondo.
Judge, I'm Tommy Thompson here on the same case as Ms. Elizondo. It's number 32 on your calendar docket.
Good morning, Your Honor. Liliana Elizondo here on behalf of defendant. We filed a motion for a docket control conference and it was set as this status conference. So we really just wanted to check in and see when you expected that we could get a trial date and discuss potentially maybe the idea of a virtual trial. I haven't had a chance to speak to Mr. Thompson about that, but this is a very old case from 2015.
Okay, that's
That's
the
right,
other
Judge.
one.
We've been asked ready at least twice when it was in court 7 and have always been reset.
Okay, so hold on. CO 152665-I Sarita Garza versus OG Construction Company. Okay, so I know you filed the DCC and we set you for a status because I'm not doing in-person trials right now. As you heard me state, we probably wouldn't be getting to an in-person trial until hopefully the summer, but it would be until I get into the new courthouse, okay? Now, if you want a virtual trial, to be honest with you, I hadn't even explored that because of the difficulty with the jury panels. But that's on you all. If you all want to talk about that.
I'll need to visit with my client, Judge.
I'm sorry?
I'll need to visit with my client on that.
I mean, but now so then I'm assuming all discovery has already been conducted?
For the most part, yes, ma'am.
Okay, did you all attend mediation?
Twice.
Okay. And you all are still real far apart?
Yes, ma'am.
All right. Okay, then,
Your Honor.
go ahead.
We do have one MSJ on gross negligence, so that doesn't dispose of all of the claims. And we also had some special exceptions that we will likely get set sometime soon. But other than that, we've made an offer of judgment, and that's pretty much, there shouldn't be anything left to do other than that, since we wrapped up the last depots the last time we thought we were going to trial.
Yeah, Judge, we've announced ready, both of us, twice, at least, maybe 3 times. And it had always been reset.
Could be more.
Could be more, yeah.
Well, you're one of the older cases, so you'll be going up probably in the first batch. I anticipate that once we start trials, I'll be in trial a lot. So that we'll be playing catch up for a good while. But the best that I can do right now is, of course, retain you on the docket, and I'll have you come back in February. In February, I should be able to start seeing what our trial docket will be looking like. I have no idea when we're getting into that new courthouse, but by then we should be able to know. Okay, so I'll have y'all come back on February the 9th, and I know you all are ready, so we'll make a notation that you all are ready. So we'll come back on February the 9th at 9:30.
Thank you, Your Honor. May I be excused?
Yes, you may be excused. All right, thank you.
Have a good day. Bye-bye.
Julia Hernandez, what other case do you have? I don't want to keep you on. I'm sorry, I didn't know you had another one.
It's okay, Judge. I have F2539-09-9 with Maria Ramirez Hernandez.
Okay, do you know what number it is on the court docket?
Number 29.
Number 29?
Yes.
Okay, so, and the attorney on the other side, Ms. Ramirez, is who?
Dulce Hernandez.
Okay, all right, I do see that Ms. Hernandez is present.
Yes.
All right, and are you all having your hearing today, or is there an announcement?
Your Honor, we 3 have conferred over the phone the last day or so, and we agree that we have reached an agreement, and we would like a little bit of time, maybe 30 days to finalize and prepare that agreement.
Okay, Ms. Hernandez, is that your understanding?
Yes, Your Honor.
Yes, sir.
Yes, and I do have my client. She should be Crystal Garcia. She should be present, Your Honor. I'm on my phone, so I can't see all the people.
Okay. And I'm sorry, Miss Julia Hernandez as well. Is that your understanding?
Yes, Your Honor.
Okay, so I'll go ahead and give you all an opportunity to get that together, and I'll have you come back on November the 10th. And at that time, be prepared to prove it up, please. And that'll be at 9:30.
Thank you. Yes, on 2 motions.
Okay, but everything was settled, correct?
Yes, Your Honor. It was and a modification, and we did reach an agreement. So we'll have that order for you by the 10th, Your Honor.
Okay.
Yes.
All right, then we'll prove it up at that time, and make sure that the AG's office also has signs off on that order.
Yes, Your Honor.
All right.
All right, anything else?
No.
No, that's all I have, Your Honor. May I be excused?
Yes, you may be excused.
Thank you.
May I be excused?
Yes, you may be excused.
Thank you, Your Honor.
Okay, thank you. Okay, Attorney Lisa Vasquez Garza.
Good
Good morning, Your Honor.
Good morning, Your Honor.
I have two cases on your docket. The first one is number 31.
All right, that's CL 140028-I Anselmo Hernandez versus Marlise Robertson.
Good
Yes.
morning, Judge. Nelda Trevino on behalf of the plaintiff, Anselmo Hernandez Jr.
Lisa Vasquez Garza on behalf of the defendant, Your Honor.
Okay, and what is the announcement?
Judge, this was another one similar to what you just heard. This is a very old case. I had filed a motion for docket control conference, and then the court set it for a status. This case has been mediated. Unfortunately, we didn't really get close to resolution. It was mediated a while back. We've secured our expert's deposition, trial testimony. So from our perspective, this case is ready for trial.
And Your Honor, just for the record, and Ms. Vasquez can correct me if I'm wrong, because I was just brought into this case last month. But I believe that the deposition of your expert, Ms. Vasquez, has not been taken. It's been noticed, but it didn't proceed, correct? Last October? And like I said, please correct me if I'm wrong. I was reviewing the file last night and this morning, and I believe that there's notations in there that Dr. Ramos, it was noticed, but I don't believe that the deposition went forward.
I see a video of him, Judge, but I haven't looked at it clearly, so I assume that it did, but I see a video of him. But if she has information that perhaps it started and then stopped, that might have, let me see.
And while Ms. Vasquez is doing that, Your Honor, for the court, yes, I did see that other depositions have been taken of the plaintiff, the defendant. The case has been mediated. It is an old file. I don't think that my client would want a Zoom trial. So if you can just put us on the docket for a trial setting, we're at the court's discretion.
Yes, Your Honor, and I'm looking, I did find the transcript. It was 105 pages, so we did secure the trial deposition of our expert. And same announcement, Judge. I know we're kind of at the mercy of the court as to when the court thinks that they'll start hearing some jury trials.
Okay, well then I'll have you come back then on February the 9th at 9:30, and hopefully by then we'll be able to know what our trial docket is going to look like.
Okay, Judge, and thank you, Ms. Vasquez, for that clarification. I apologize. Thank you. And Judge, may I be excused? I don't have anything else.
Yes, you certainly may.
Thank you.
Okay, your next case?
Yes, Judge, and the next one I have is number 36.
CL 196312-I Abigail de Hoyos et al. Versus Benita Zuniga.
Yes, Your Honor. Lisa Vasquez Garza on behalf of the defendant.
Andres Lopez for the plaintiffs, Your Honor.
Judge, same announcement, although this case is not as old as the other case was. I believe that we have essentially exhausted our efforts to try and resolve the case. This case did go to mediation. Mr. Daniel Hernandez, there was a mediator's proposal, which the defendants did accept. Unfortunately, the plaintiffs did not. So we're at a situation where just also kind of on standby for obtaining a new trial setting.
And Mr. Lopez, you represent all three plaintiffs?
Yes, Your Honor.
Okay. Okay, well then it'll be the same. Come back on February the 9th at 9:30, and that way at that time, hopefully I can already give you a better picture as to trial settings.
Yes, ma'am. That's all I have. May I be excused?
Yes, you may. Mr. Lopez, do you have another case?
No, ma'am. May I be excused?
You certainly may.
Thank you. Have a good day.
Thank you. Okay, Attorney Eddie Trevino. Mr. Trevino? Okay, Attorney Sonia de Ochoa.
Good morning, Your Honor. We're number 19 on the docket, and I'm Sonia de Ochoa standing in for L. Aaron Pena.
Okay, that's CL 21590-I Geico Insurance versus Danielle Alanis et al.
And yes, and we're the attorneys for the defendant, Olga Alanis, and Daniel Alanis. And Ms. Gigi is present. She's the opposing counsel, I believe.
Yes, good morning.
Okay, good morning. All right, and are you moving forward? Are we here on a status or are we moving forward on Geico's motion for summary judgment?
Your Honor, I'm requesting for more time. Mr. Peña has been ill since the weekend. So I'm asking if we can reset it for 30 days so that he can respond and be present at the hearing.
Okay, and do you pronounce your last name Matter or?
Matar.
Matar, I apologize. Okay, Ms. Matar, any objection to their request?
No, Your Honor, but I would ask that since we were ready to go today, that this be the only continuance that is allowed on the motion.
Okay, so I do know that Mr. Peña has been ill, so I'm gonna grant that motion. I'm gonna grant their request. I'm gonna reset you for November the 15th.
Okay.
Thank you, Your Honor. I have no more matter before this court. May I be excused?
Yes, and that'll be at 9:30.
All right, thank you.
And November 15th at 9:30?
Yes, ma'am.
Perfect, Your Honor. And I also do not have any further business with the court, if I may be excused.
You certainly may.
Thank you. Take care.
Thank you. Attorney James Sahadi?
Yes, good morning, Your Honor. James Sadi here at number 49 on the docket.
Okay, that's F1559-21-9 in the matter of the marriage of Victor Ruiz Rodriguez and Socorro Peralta Ruiz.
Yes, Judge. Last time we were present, we had urged a motion for substitute service, which the court granted. That service was affected. At that time, Your Honor had also requested that I submit an order appointing attorney ad litem. Edna Cedillo was appointed, and Ms. Cedillo has had a chance to visit with my client.
That's correct, Your Honor. I'm on. Good morning.
Good morning, ma'am. Okay, so then go ahead, Ms. Cedillo, your report.
Your Honor, with regards to this case, Judge, one, I don't believe that it's ripe at this point. If counsel intends to proceed today, I believe that the 20th day after the return would actually be sometime after October the 11th. In addition to that, Your Honor, I was able to locate an adult child who provided me with a phone number for the respondent in this matter. I did contact the respondent. She returned the call to the office, at which point my staff indicated that she wasn't interested. She had other things to do and needed to focus on her work and some doctor's appointments, Judge, and hung up on us. So we have a phone number, but short of that, Judge, there's no other information that I can relay to the court.
Okay. Then we'll proceed. Since Mr. Sahadi, it's not ripe at this time, I'll give you a date right after October the 11th so that we can proceed with it. Ms. Rivera, do we still have some room on October 20th for approval?
Yes, Judge, that's fine. We can fit them in.
All right, October 20th at 9:30 for our final hearing.
Perfect. Thank you, Judge.
Your Honor, does the court wish for me to follow up in writing? And may I be excused from the final hearing, Judge?
Okay, so you've already given the court the report on the respondent, so you've done your part. So you don't have to be at the final hearing.
Yes, Your Honor. And if I hear from her between now and then, Judge, I will let the court know.
Okay, and also just make sure that you work out your fee.
Yes, that's been taken care of by Mr. Sahadi's client. Thank you, Your Honor.
Okay. All right, then we'll see you, Mr. Sahadi, and you and your client on October 20th at 9:30, sir.
Thank you, ma'am. May I be excused?
Yes, you certainly may.
Yes.
Thank you, Judge. Have a wonderful day.
Likewise. Okay, Attorney Frank Martinez. Mr. Frank Martinez? Okay, I'll recall that case shortly. Mr. Eddie Trevino?
Judge, we're present and we're ready to proceed on an uncontested, agreed to divorce. There's a waiver on file. That would be number 4 on the court's docket, F 1553-21-9.
Okay, and is Ms. Gomez present?
Yes, she was.
Okay, let me go ahead. So you'll be proving it up with Ms. Gomez?
That's correct, Judge.
Okay, Ms. Gomez, please raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you may lower your hand. You may proceed, Mr. Trevino.
Thank you, Your Honor. There's a waiver on file. We'd ask the court to take judicial notice of all of the court's documents. Let's see. Ms. Gomez, will you say your name for the record, please?
Samantha Lee Gomez.
And you've lived in the state of Texas for the last 180 days and the county of Hidalgo for the last 90 days prior to filing the divorce?
Yes.
And the divorce was filed back on April 7th, 2021. Is that correct?
Yes.
Okay. You're married to Randy Chavez. You were married on July 9th, 2011, and you separated, and you've been separated since May of 2014. Is that correct?
Yes.
Your marriage has become insupportable because of discord or conflict of personalities that destroys the legitimate ends of the marriage relationship, correct?
Correct.
And there's no reasonable expectation of reconciliation.
Correct.
You have one child born during this marriage, is that correct?
Yes.
The child's name is Zoe Olivia Chavez, age 7.
Yes.
You didn't adopt any children during your marriage, is that correct? During this marriage?
Correct. We did not.
And you are not expecting a child at this time?
No.
Now, you and your husband have agreed to the terms of your divorce, correct?
Correct.
They are as follows. There will be managing conservator, with you being the primary conservator, correct?
Yes.
He will have standard visitation rights, correct?
Yes.
And child support will be in the amount of $227.95, correct?
Yes. Correct.
Okay, and there's going to be zero reimbursement on the medical insurance.
Correct.
You have agreed to provide the insurance which you have through your employment.
Yes.
Okay. Property, as far as the property is concerned, he will keep the home located at 2109 Wren Lane, Edinburgh, Texas.
Yes. Renee Lee.
And each of you will keep whatever personal property you have in your possession.
Yes.
And each of you will pay whatever debts that you have incurred since your separation.
Yes.
And you're asking the court for a divorce.
Yes.
Judge, I have nothing further of this witness. I don't think there's Mr. Chavez was online.
No.
Okay, so Ms. Gomez, do you believe that this agreement is in the best interest of your child?
Yes.
Okay, and you're asking the court for a divorce today?
Yes, ma'am.
Okay, the court will grant the divorce today and will grant the relief as requested and testified to on the record. And this will be set forth in greater detail in a divorce decree to be signed by you and your husband. Has that already been done, Mr. Trevino?
Yes, Your Honor. I believe it's been e-filed.
Okay, then I'll ask for that to be forwarded to my queue.
Thank you, Your Honor.
Okay, anything else?
Judge, I have one other case on your docket.
Okay, Ms. Gomez, that takes care of your case, so you are excused, ma'am.
Thank you.
Thank you. Okay, what other case, Mr. Trevino?
I have number 17. That would be CL 19 4695.
Okay, Rosalinda Uresti et al. Is Esperanza Ramirez?
That's correct, Judge. And we found the motion to withdraw. in this
Okay,
particular-
is there opposing counsel on this one?
No, not that I'm aware of.
Okay. Okay, and was proper notice given to your clients?
Yes, proper notice was given. We have the return on the certified mail.
Okay, and is there an order on file?
I'm not sure, Judge.
Okay. The motion to withdraw will be granted. If there's not an order on file, just get one filed so that it can be forwarded to my queue.
We will do.
Okay, anything else?
Nothing further, may I be excused?
Yes, you may.
Thank you.
Thank you. Okay, sir, was Mr. Martinez ready?
Good morning, Your Honor.
Yes, sir.
My name is Willie Barra. I'm the assistant to Mr. Martinez, and he asked me to tell you that he's in another hearing.
Okay, that's fine. Just let us know when he's back on.
Thank you, Judge. Appreciate
Okay.
that.
Attorney Hector Garcia?
Good morning, Your Honor.
Good morning,
Hector Garcia
sir.
here for the plaintiffs from the law office of Bobby Garcia.
Okay, what number?
Number 33 on your docket, that's what I understand. CL 154199. Aye.
Okay, and that's Jenny De Leon versus Cajun Operating Company.
That's correct, Your Honor.
And
Your
who's
Honor,
here
Rick-
for the defense?
Rick Zuniga on behalf of defendant.
Okay. And what is the announcement?
He's just here for status, Your Honor.
Okay. I have a notation that someone may be asking for a bench trial request. Is that still?
I'm not aware of it, Your Honor.
Okay, all right.
I'm certainly open to that if anyone, if it might be a good way for us to short circuit all of this.
Okay, well, I'll let you all discuss that. And if you are, just let us, if you do decide that you are in agreement to a bench trial, just file a motion for a docket control conference indicating that it's for a bench trial, and we'll give you a DCC date for a bench trial. If you all do decide to do that. Other than that, so then I'm assuming since it's a 2015 case, all discovery, everything has already been worked up?
No, Your Honor.
Your Honor,
No.
you may recall this is a case where the discovery period is open and closed several times over the years. And Mr. Garcia would like to take some additional depositions at this point, and I'm opposed to reopening it. And he has not filed a motion to reopen the discovery period. He attempted to file a motion for docket control conference, which this court turned into a status hearing. So there is no current DCC set. I think his hope was to get a new trial date, get a DCC that then gave new deadlines. And we would, of course, be opposed to that. We just need a trial date from our perspective.
Yeah, Your Honor, we made attempts to try to get the depots, get depot dates to no avail. So what we're gonna do, we're just gonna we're gonna locate and notice the witnesses, and we'll go from there.
Well, the thing is now I remember when Mr. Zuniga was saying that. Now I do remember the position that this case is in. So, I mean, you all are going to have to work that out as far as, I mean, right now at this point, being that there is no trial setting date, there is nothing other than just waiting for to get the trial setting. So the best that I can do is, if it will be a bench trial, then file, like I said, a motion for DCC and ask for a bench trial setting, and we'll get you set for a DCC so we can get that on the docket. And if not, then I'll have you come back on February the 9th, and at which time I should be able to give you pre-trial and trial dates.
Your Honor, just from my information, if we were to go with a bench trial, then we'll open up the depot dates, I mean, to take depots or not?
I mean, well, technically it would be, the docket control order would be the one that would be controlling in that case.
Correct.
So, I mean, it would have to be, it depends what you all agree to on the bench trial setting. If you agree to a quick bench trial setting, then there wouldn't be any long deadlines. If it's a bench trial setting far out, then of course you're gonna risk, Mr. Zuniga, those deadlines will be back open. So you all, it's what you all decide to do.
We're just gonna go ahead.
Understood, Your Honor.
notice it, and then
Mr.
you
Garcia,
can-
you're welcome to call my office and talk about a bench trial. That hasn't been brought up to me before, but willing to listen.
No, I'm always willing to listen, but before we even get to the bench trial, I like to take the depots first.
Well, I think at this point, with nothing being set, that deadline's closed, is what Mr. Zuniga is reminding us about. So I don't know how that's gonna happen, but I'm gonna let you all discuss that.
Yeah. As far as the bench trial, I don't know what, it will go through because it's Bobby Garcia's case. And
I understand.
He's not doing bench trials, but.
Okay, just let us know. Other than that, I'll need you to come back on February the 9th at 9:30.
February the 9th?
Yes.
Thank you, Judge.
22,
Hopefully we'll have a good idea when we'll be in the courthouse by that point, and we'll get a trial date. This will be a quick one, Judge. It's not a
That's
not a
my
lot.
hope too. Okay, anything else?
That's all I have before the court. May I be excused?
Yes,
No,
you
Your
may.
Honor.
Thank you, Judge.
Thank you, and stay safe out there.
Thank
everybody.
you. All right, Attorney Lindsay Guerra.
Morning, Your Honor.
Good morning.
I have number 40 on the court's docket, Border versus Landstar. Plaintiff's counsel is Javier and he had a TML hearing this morning. So he asked me to make an announcement for the court. We were just requesting a trial date. We had one before the court, before the case was transferred to this court, but of course it wouldn't have gone regardless. But if we can just get back on the docket, I heard the court giving February announcement dates to other parties. So if I'm assuming that we'll follow under the same category.
Good morning, Your Honor. This is Dora Garza. Is this on Border Warehouse versus Landstar?
Yes, ma'am.
Okay, I represent the second defendant, 3GP Transport Inc.
Okay, so yes, Ms. Guerra, you are correct. It would be that if you're requesting a jury trial setting, then it would be that you come back on February the 9th at 9:30, and at which time I hope to be able to have a better picture of my jury trial docket. So everything's been done on this case and ready to go?
Actually not, Your Honor. This is a fairly small business-to-business dispute, and we've just done some written discovery, but I think anything we might need to do if we decide we actually need a deposition, we'll take care of before February.
Okay, sounds good.
Great, Your Honor. I have no further business. May I be excused?
Yes, ma'am. Ms. Garza?
Same announcement, Your Honor.
Okay. Thank you. Y'all have a good day.
Thank you.
Okay, Frank, you ready?
Ready, Judge.
Okay, what number?
Number 6 on your civil docket, Judge.
F 2177-21-9 in the matter of the marriage of Ricardo Martinez and Saley Martinez.
Yes, Judge. My client, Ricardo Martinez, is present, and I did see a respondent a while ago on the screen.
Yes, I am. I'm present too.
He's gonna need an interpreter, Judge.
Who needs an interpreter?
My client, Judge. My client.
Okay, so is this an agreed divorce?
It is.
Okay, then just make sure when you enter the agreement into the record that you go slow so that my translator can translate it properly, okay?
Yes, ma'am.
All right. So, Mr. Martinez and Ms. Martinez, please raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Ms. Martinez?
Yes, I do.
Okay, Ms. Castañeda, translate.
Mr. Martínez, jura que el testimonio que está a punto de dar es la verdad, toda la verdad y nada más que la verdad.
Sí.
Yes.
Okay, you all may lower your hands.
I proceed, Judge.
Yes, sir.
Would you please state your name for the record?
Por favor, dice su nombre para...
No, Ms. Martinez, we're gonna start the testimony with Mr. Martinez since he is the petitioner. So just listen to the agreement as testified to onto the record, okay?
Okay.
Go ahead, Ms. Castañeda.
Mr. Martínez, por favor, diga su nombre para el estado del registro.
Ricardo Martínez.
Ricardo Martínez.
And are you presently married to Saley Martinez?
¿Y está usted ahorita casado con Saley Martínez?
Sí.
Yes.
Prior to filing this divorce, did you live in the state of Texas for 6 months and the county of Hidalgo for 90 days?
Antes de meter esta petición, era usted domiciliario de Texas por los precedentes 6 meses y residente de este condado por los precedentes 90 días?
Sí.
Yes.
And did you marry on or about July of 1999 and separate on or about November of 2020?
Y usted se casó con julio del 1999 y dejaron de vivir como esposos en noviembre del 2020?
Sí.
Yes.
And had your marriage become insupportable because of discord or conflicts within the marriage?
¿Y su matrimonio ha sido insoportable durante el matrimonio?
Sí.
Yes.
Is there any chance of reconciliation?
¿Hay alguna manera de reconciliación?
No.
No.
Now, there were children born during this marriage. Will you please state their names?
¿Hubo niños en este matrimonio? Por favor, ¿puede decir sus nombres?
Sí. Jonathan Martínez, Saley Martínez, Mark Martínez, Sarai Martínez, y Yaretsi Martínez.
Okay. Mark Martínez, Saley Martínez, Sarahi Martínez, and Yaretsi Martínez.
Sí. And you're agreeing to joint managing conservatorship with respondent being primary and standard possession for you?
Y ustedes llegaron a un acuerdo de ser conservadores de gestión junta?
Sí.
Yes.
Respondent being primary?
Con Miss Ailey siendo la encuesta de la primaria de encuesta, de ella tener la custodia primaria?
Sí.
Yes.
Now, regarding child support, you'll be paying her $500 a month in child support and also $54 a month for insurance. Is that correct?
Ok, tocante a la manutención, usted está pagando $500 al mes y 54 por el médico?
Sí.
Yes.
Regarding property, there is a home, and both of you have agreed for the sale of that home located at 16259 Cove Lane in Edinburgh, Texas.
Sir, could you repeat the address, please?
16259 Cove Lane in Edinburgh, Texas.
Okay. Y tocante a la propiedad, ustedes han llegado a un acuerdo, la propiedad está en 16259 Cove Lane en Edimburgo?
Sí.
And
Yes.
you agreed to sell that property when your youngest child turns 18, unless otherwise agreed mutually by both of you?
Ok, y ustedes llegaron a un acuerdo de vender esa propiedad cuando el niño más pequeño cumpla 18.
Sí.
Yes.
Unless otherwise agreed by both of you to sell sooner.
A menos que ustedes lleguen a un acuerdo de vender más pronto.
Sí.
Yes.
Now, respondent will continue living in that home, and she'll be responsible for all the utilities in the home and the maintenance of the home.
Okay, y la demandada va a seguir viviendo en esa casa por ahorita y ella va a ser encargada de los arreglos de la casa.
Sí.
Yes.
And you will be responsible for paying the taxes on that home for the 2020 taxes.
¿Y usted va a ser responsable de pagar las taxas del 2020?
Sí.
Yes.
She will be responsible for paying the 2018 taxes that are still due.
¿Y ella es responsable de pagar las taxas del 2018 que todavía se deben?
Sí.
Yes.
After those taxes are paid, by that I mean the 2020 taxes, the ones that are currently due, both of you will be after that date pay the taxes 50-50, any future taxes, property taxes.
Ok, después de que se paguen las taxas del 2020 que se deben ahorita, después van a pagar ustedes las taxas 50%.
Sí.
Yes.
Regarding any other property you have in your possession, you're going to stay with.
Tocante cualquier otra propiedad que tenga usted en su posición, usted se va a quedar con eso.
Sí.
Yes.
You also stay with any monies that you may have in any bank accounts and any retirement.
También se va a quedar con cualquier otro dinero que tenga en cuentas de banco o en el retirement, que es la jubilación.
Sí.
Yes.
And you're also going to stay with the 2018 Nissan Sentra.
Y también se va a quedar con una 2018 Nissan Sentra.
Sí.
Yes.
She's going to stay with whatever personal belongings she currently has in her possession.
Y ella se va a quedar con cualquier posesiones que ella tenga en su posesión.
Sí.
Yes.
Also with any monies in bank accounts or retirement.
Y también con cualquier dinero en las cuentas de banco o jubilación.
Sí.
Yes.
She's also going to stay with the 2014 Chevrolet Sonic.
Y también ella se va a quedar con un 2014 Chevrolet Sonic.
Sí.
Yes.
Whatever debt is in your name, you're going to be responsible for. Whatever debt is in her name, she's going to be responsible for.
Cualquier deuda que esté en nombre de usted, usted se va a quedar con ella. Cualquier deuda que ella tenga, se va a quedar con la deuda ella también.
Sí.
Yes.
Are you asking the court to grant you a divorce?
Le está pidiendo a esta corte que le conceda el divorcio.
Sí.
Yes.
No further questions for my time, Judge.
Okay. Now, do you have any questions of Ms. Martinez?
No, I don't.
No, I'm asking if Mr. Martinez has any questions of you.
Just two, Judge.
Okay, go ahead.
Ms. Martinez, are you asking for a last name change?
No.
And you heard me read the agreement to Mr. Martinez. Is that your understanding of the agreement, and are you asking the court to approve it?
Yes, I do.
Are you asking the court to grant you a divorce?
Yes.
No further questions, Judge.
Okay, the court will grant the relief as requested and testified to on the record and will further grant the divorce as well. This will be set forth in further detail in an agreed final divorce decree to be signed by the parties and by you, Mr. Martinez.
Yes, Judge.
And how much time do you need to submit that to the court?
I can, by Monday, Judge.
Okay, then I'll go ahead and I'll set a tickler for the 15th, just to be safe.
Yes, ma'am. And that's all I have, Judge. May I be excused?
Yes, you and the parties may be excused.
Thank you. You all be safe.
Thank you.
Thanks.
Okay, Perla Navarro.
Yes.
Okay, how can I help you, ma'am?
Yes, I think we filed the decree wrong because we put 50-50 and we share everything together with the
Um,
kid regarding my kids. We're number 3, sorry.
Okay, so then F1091-21-9, so your divorce decree, you
Yes.
filed it wrong?
Yes, I believe so, because we don't want child support. We share everything, equally between the dad and I.
Okay, so then are you going to be fixing that decree and refiling it?
Yes, ma'am.
Okay. And how much time do you need to fix it and refile?
A couple days.
Okay, then I'll have you come back on November the 10th at 9:30.
Okay.
Okay,
Thank
you're
you
excused.
so much. Thank you.
Thank you. Okay, Attorney Cassandra Diaz.
Hi, Your Honor. I'm here on case 38.
I'm sorry, what number?
38. Herrera versus Mayers.
Okay, that's CL 21380-I, Ashley Herrera versus Erica Mares.
So I'm here for the defendant. I'm standing in for Mr. Moya. This is for a status conference. Mediation was conducted on September 14th. It was unsuccessful. So we're requesting a trial date. I don't see plaintiff's counsel on here. I saw him earlier, but I don't know where he went.
Okay, so you'll come back on February the 9th at 9:30.
Okay.
And then that way, at that point, we should hopefully be able to give you a better indication of process.
Okay, that's the thing I had. May I be excused?
You certainly may.
Thank you.
Thank you. Okay, Attorney David Guarena.
Good morning, Judge. I have number 47 on your civil docket.
Okay, F 1320-20-9 in the matter of the marriage of David Lopez versus Stephanie Vallejo.
Good morning, Judge. David Guarena for Mr. David Lopez. Savannah Gonzalez represents Ms. Vallejo, Judge. She's in the 370th. I just had a quick announcement on this case. We filed a Rule 11 agreement yesterday. We're scheduled for mediation on this case on October 28th with Melinda Diaz. So we need a date after October 28th to come back and report to the court.
Okay, November 10th at 9:30.
Thank you, Judge. I'll let Ms. Gonzalez's office know, and that's all I have. May I be excused?
You certainly may.
Thank you, Judge. Stay safe.
Thank you. Attorney Daniel Ramirez.
Yes, good morning, Judge. Daniel Ramirez, for the record, in cause number F474129. I represent Melissa Gonzalez, and she's already online, Judge. This is a divorce case that had been initiated by Ms. Gonzalez pro se. Then she hired me to represent her on the divorce case. And so I filed a notice of appearance. I noticed, Judge, that you had a status hearing for today. Apparently, there's been some activity already in the case. After Ms. Gonzalez filed the divorce petition, Mr. Gerardo Gonzalez was represented by Eddie Trevino. But then Mr. Trevino withdrew from the representation of the respondent, Gerardo Gonzalez. It would have been, I guess, in August of 2021. In the meantime, the court had referred this case for mediation prior to Mr. Trevino withdrawing. The court had referred this case to mediation in June of 2021 and had appointed Ms. Del Bosque to be the mediator. And I think Ms. Del Bosque, from my client's understanding from my client, is that Ms. Cynthia Del Bosque tried to conduct a mediation, but Mr. Gerardo Gonzalez did not appear at the mediation. I'm just kind of going through a brief history. So today is the status hearing, and that should give the court an update where we're at this point. It's a divorce case, and certainly we would like to proceed with the mediation since the court has ordered it. I've already contacted Ms. Del Bosque, asking her for new mediation dates. I haven't had a response from her. I just contacted her yesterday.
Okay, so then, Mr. Gonzalez is still pro se at this point?
I believe so, since Mr. Trevino withdrew, and in the registry of the court in the docket, I don't see that anybody else has made an appearance, Judge.
Okay.
For him.
All right, then I'll give you an opportunity to get that set up with Ms. Del Bosque and see if you can have Mr. Gonzalez cooperate with the process. And I'll go ahead and give you all 30 days to do that. And I'll have you come back on November the 15th at 9:30.
Okay. That's fine, Judge.
Okay, anything else?
No, ma'am. Thank you. Thank you.
Okay, thank you, sir.
Yes.
All right. Okay. Miss Lucy Thompson?
Yes, Your Honor. We're here on number 9 on the court's docket. Mrs. Trevino, the opposing party, is pro se, I believe, unless she's hired a lawyer recently. And Kathy Alvarado is the ad litem, Your Honor.
Good morning, Judge Catarina Alvarado, ad litem in this case.
Good morning, Andrea Trevino, present, pro se.
Okay, so, and are we ready to proceed with a final hearing?
Judge, I would be deferring to the ad litem as to whether she has a final recommendation or not. I don't know if she needs additional time. I know there's been a lot going on, so I defer to her.
Judge, I do have a recommendation, and I don't know if I was an ad litem or an amicus in this case, but I do have a recommendation for the court. I believe that with all that's been going on with the child and her school and drop-offs and pickups and missing uniforms and things of that nature, I have been communicating with the parties via email. At one point, Ms. Trevino asked me not to call her, to communicate by email only. I don't know why, but I believe that Mr. Rodriguez should be the primary and handle all drop-offs and pickups at school during his time of possession. I think it's been difficult going back and forth, the schedule that they have, and Ms. Trevino has had some trouble doing her part with drop-offs and pickups and getting her in her uniform and things of that nature. That is my recommendation at this time. I haven't met with Ms. Trevino in person since our initial meeting. I did communicate via email with her. She did tell me that she was going to, that she had no trouble getting her to school or complying with the court's order. Yet since that email, I've received certain documentation from Mr. Rodriguez that Ms. Trevino has not been complying with that. So at this point, Judge, I believe that it's in the child's best interest that dad be primary.
And what type of visitation are you suggesting for Ms. Trevino?
Judge, I believe an extended possession order would be fine if Ms. Trevino can comply with getting the child to school on time and in her proper uniform and with her backpack and everything that she needs to attend school. If she can't do that, Judge, then I would recommend a standard possession order.
And how old is the child?
She is 5.
5.
Okay. Ms. Trevino, I'll give you an opportunity to respond.
Yes, Your Honor, if I may. I have been able to take the child to and from school on my possession days that I should have child. There has been no substantial change as far as me being remarried or anything for me to be changed as far as not being primary to the child. I do believe that it, the best interest to my child, she has been changing because it is interfering with her schedule during the school week. So I just would rather have something that's more stable for my child. That doesn't interfere, even if it's extended, because of the fact that still interfering with her school Monday through Friday. I did try to see if I could get the mediation for it to be still as it is with the OAG order that was signed by me and the father of the child. When we actually started this, there was already an order standing with the Office of the Attorney General.
Okay, Ms. Thompson, did you want to add anything?
Judge, I'm a little confused, but just so the court isn't misinformed, the Attorney General order was when the child was born. There was an immediate modification filed, and the visitation for the child changed, I believe, when she was 2 years old or a year and a half, something like that. I'll pull it up. And then Dad has filed a petition to modify this time because of the issues that we've had with the AB plan that has been in existence. If the court needs testimony from my client, there's issues like whenever mom brings the child to dad, she changes the child's clothes at the exchange. Since our last status hearing, I can testify to this part and tell the court this part. Since August 30th, our last hearing, on August 31st, mom texts dad saying, I can't take the child to school. I need you to do it at 7:15 in the morning. She didn't have her uniform. She didn't have her backpack. She didn't have her mask. She didn't have a hand sanitizer. A week later, September 6th, mom showed up at dad's house to pick up the child, yet it wasn't her time to do so, and refused to take the backpack with her because it's not her backpack at her mom's house. On September 10th, again, mom asked dad to pick up the child from school. On September 14th, again, mom asked dad to pick up the child from school. On September 15th at 7:40 a.m., the mom dropped off the child at dad's house to take her to school, and the child didn't have her uniform. And then just 10 days ago, September 24th, the mom didn't pick up the child from school. I understand the idea of an AB plan. We've advocated for that, and we thought that that was a good thing, but things have changed to where mom's not able to comply with it, and it's not working out for this child.
Okay.
I'm sorry, Judge. I would agree with that. And again, my communication with Ms. Trevino via email, and I've informed her, I can't give her legal advice. It seems that she in her email says that she consults with an attorney on a limited scope representation. I informed her in my email that I'm not here to give her legal advice, but there is an order that has to be complied with, and that order, and it hasn't been complied with. She did tell me in the email she would be complying, and that was on September 15th. From September 15th forward, those things that Ms. Thompson just announced have been happening. And I just feel that I agree with Ms. Lavino in saying that the child does need a structure and a stable order. And it's unfortunate, but I don't believe that Ms. Trevino can provide that to her at this time.
Okay, so what I do want to do is I am gonna, and I do hear some concern, and I do want to have some testimony put on the record. And I'm gonna have some questions of Ms. Trevino, and I want to be able to give some attention to this. But I'm gonna have you all come back this afternoon. Ms. Thompson, Ms. Alvarado, can all of y'all look to see if you have time to come back at 2 o'clock?
I'm available, Your Honor.
Yes, Your Honor.
Okay, a link will be sent to you all and to Ms. Trevino, since she's pro se, for you all to come back at 2 p.m. and be prepared to at least set aside about an hour or so.
Okay, Your Honor.
Okay?
Yes, Judge. We will see you then, Judge. Thank you.
Thank you.
Sorry.
You're temporarily excused.
Thank you.
Judge, if Ms. Trevino can provide me her email?
Yes. Andrea Trevino 967@yahoo.com.
Thank you.
Okay, so Mr. Gutierrez, you have 6 cases, is that correct?
Yes, Your Honor.
Okay, and what's your first case?
I have, let's see. Like 3 of them are set for motion for default. 2 status conferences and then maybe a bench trial, but it's showing canceled in the system.
Okay, well, what number are you on the court's docket?
You know what, Your Honor? I'm not privy to the docket. I didn't get that from main counsel, so.
Your Honor, I have them noted.
Okay, go ahead.
Okay, Judge, the first one would be number 15.
Okay, that's CL 191412-I, TD Auto Finance versus Jose Sanchez.
Yes, Your Honor, that's a motion for default judgment.
Okay,
Ready to proceed, Your Honor.
Mr. Damian, please call out the name Jose Sanchez 3 times.
Yes, ma'am. Jose M. Sanchez, Jose Sanchez, Jose Sanchez.
Okay, Mr. Gutierrez, what date was Mr. Sanchez served?
Served on June 14th of 2019, Your Honor.
And was an answer ever filed?
Not that I'm seeing, Your Honor.
Okay, you may proceed.
May it please the court, Your Honor, this has to do with a 2016 GMC Sierra. The account related ends in 3238. The parties entered into this agreement back in August of 2016. We're asking the court take judicial notice of the entire file and enter into evidence the business records affidavit of a Scott Brown. Therein, there's the contract and a ledger, such as proceeds that are from the car's return and such for the court's consideration. We have a proposed order on file as well. I did see a SACRA for non-active duty military status, and the damages, Your Honor, are $14,723.87 plus court costs of $378.83, Your Honor, and applicable post-judgment interest of 5%.
Okay, the court will take judicial notice of all the documents in the court's file, specifically that defendant was properly served and no answer was filed. Therefore, the court will grant the relief as requested and grant the default judgment. Is there an order on file?
Yes, Your Honor. I believe it was August of 2019. There was one.
Okay, then I'll ask for that order to be forwarded.
Understood.
Okay, and the next one, Ms. Rivera, do you know?
21 and 22, Your Honor.
Okay, 21, CL 210016-I, Bank of America versus Kayla Fernandez.
Yes, Your Honor. We're moving for a motion for default judgment.
Okay, Mr. Damian, please call out the name Kayla Fernandez 3 times.
Yes, ma'am. Kayla Janelle Fernandez, Kayla Fernandez, Kayla Fernandez.
Okay, the name being called out 3 times, no response. Mr. Gutierrez, you may proceed. What date was Ms. Fernandez served?
Your Honor, I didn't write that down on this one, and I didn't print it out either.
Your Honor, she was served on April the 19th of 2021.
Okay, April 19, 2021, and was any answer, do you show that any answer was filed?
No, Your Honor, the return does state. I'm sorry, Judge. No, Judge, there was no answer at all.
Okay. Now, and for this case, was the defendant given notice of today's hearing?
I don't show that specifically on my side, Your Honor.
Yes, Judge, the mailing address was included on the order setting hearing, Your Honor.
Okay. All right, so then being that the answer date has already passed, Mr. Gutierrez, you may proceed.
Your Honor, we're asking redress regarding a Spirit credit card ending in 8177. The parties entered into this agreement for this line of credit back in March 2017. We're asking the court to take judicial notice of the entire file and especially enter into evidence Exhibit 2, which is a business records affidavit from Sherry Griffin. Therein, Ms. Griffin provides the fact that there was this account, there was a delinquency in the account and created grounds for this petition. She provides the last payment date of May of 2019 and charge off date of the same month. She provides the statement accordingly and provides non-active duty military status affidavits. And we're seeking damages in the amount of $3,036.01, Your Honor, plus court costs.
Okay, then the court will take judicial notice of all the documents in the court's file, will grant the relief as requested and put on the record. And is there an order on file?
I didn't see it on my end, Your Honor.
Okay, do we show that there's an order on file?
Yes, Judge, there is a default judgment. It was filed on the 20th of April of this year.
Okay, so we can have that forwarded to our queue. Okay, CL 210026-I, Bank of America versus Joanna Gonzalez.
I believe Ms. Gonzalez might be here, Your Honor, or she was earlier.
Okay, Ms. Gonzalez.
I am here.
Okay, so are you're asking to proceed today, Mr. Gutierrez?
Yes, Your Honor.
Okay, Ms. Gonzalez, will you be retaining counsel?
Yes.
Okay, so are you requesting the court give you time to obtain counsel?
Yes, ma'am.
All right.
I did put in to Mr. Gutierrez a log from the company that I'm working with, Option One Legal, to show that I am trying to get myself together. I did communicate with them about this matter, and they expedited this part, and they did communicate to me saying that they are putting it like on their top priority.
Okay, well, I'll have y'all come back on December the 8th at 9:30. Ms. Gonzalez.
Sorry, at 1:30, Your Honor? My apologies.
9:30. 9:30. Okay, Ms. Gonzalez, can I get an email address for you?
It's Joanna, JOANNA 11990 at AOL.com.
Okay. So December 8th at 9:30, ma'am. By that time, if you're hiring counsel, see that they get on before then so they can communicate with Mr. Gutierrez's office.
Yes, ma'am.
Okay. If
Thank you.
nothing further, you may be excused.
Thank you.
Okay, and your next case, Mr. Gutierrez?
Number 34, Your Honor.
All right, that's CL 161634-I, Jefferson Capital Systems versus Alejandro Soto.
Your Honor, I may have had that Timothy Elder case. My apologies. I had another docket in which if you could please call another case, I can get back.
Number
I
37,
believe so,
Your
Your Honor. It's a motion for default judgment. If you could call another case, because I'm finishing up this other, that'd be awesome. I appreciate it.
Oh, he's on another
Thank you, Your
subject.
Honor.
I got it. I'm sorry, Judge.
My apologies, Your Honor.
Okay, so go ahead on Jefferson Capital Systems versus Mr. Soto. I have that case settled.
Yes, and I have it as paperwork needs to be filed on the settlement.
Okay, how much time do y'all need to file that?
30 days, Your Honor.
Okay, I'll go ahead and put a tickler for November the 19th.
Understood, Your Honor.
Okay. And then you have CL 196425-I, Portfolio Recovery versus Michelle Galavis.
Yes, Your Honor, and it's a similar circumstance.
Okay, then I'll go ahead and set a tickler for November the 19th for the documents. Okay, did you have another one?
Yes, Your Honor, there was and I think this one might have been canceled. It was showing canceled in the system, so there's a way to verify that it was. I have a cause number. It is CL-19-3917-I, and it's styled as One Main Financial versus Adon Martinez.
Judge, we never received an order resetting for proper notice to the defendant, so it's not set to date.
Okay, so you need to file an order resetting hearing, copying the defendant on that, Mr. Gutierrez.
Understood. All right, that was all my business before the court, Your Honor.
Okay, thank you for your patience.
Appreciate it. Thank you, Your Honor.
Okay. F 3004-21-9 in the matter of the marriage of Libby Salinas and Rodolfo Salinas.
I'm here, Honor.
Okay, and Mr. Salinas?
I'm here, sir.
Okay, so Ms. Salinas, you are currently still pro se?
That is correct.
Okay, and Mr. Salinas, you're also pro se?
Yes, ma'am. Thank you.
Okay, and have y'all come up with an agreement on this divorce?
Yes, we have.
All right, and has your divorce decree been e-filed?
It has been, it's been filed with the court.
Judge, only the petition was filed. I don't believe, unless it was this morning, the decree has not been filed.
The decree hasn't, okay.
Okay, do you see when you filed the divorce decree?
Yes, it was on August 23rd at 3:26 p.m.
Oh.
That was the order setting hearing, Your Honor.
Yeah, that was the order setting hearing. I need a final decree of divorce to be signed off by both of you.
By both of us, okay.
Now, what I will do then, since both of you are here, I can go ahead and take the testimony of both of you, and I'll give you an opportunity to put on the record what your agreement is as to what you're dividing. And then I will need a divorce decree that's signed off by both of you to be submitted to us.
Okay.
So let me go ahead and have both of you raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth? So help you God. Ms. Sain Salinas?
Yes.
And Mr. Salinas?
Yes, Your Honor.
Okay, you can lower your hands. Okay, Ms. Sain Salinas, you are the petitioner of this divorce proceeding, is that correct?
That is correct, Your Honor.
And you are currently married to Rodolfo Salinas, is that correct?
That is correct.
And you were married on or about August 9th, 1989, and ceased to live together as husband and wife on April 9th, 2021, is that correct?
Yes, ma'am.
At the time that you filed for divorce, you were a resident of Hidalgo County for at least 90 days and of the state of Texas for at least 6 months, is that correct?
That is correct.
And there is no protective order pending at this time, is that correct?
No, ma'am.
And you're asking for a divorce today because your marriage has become insupportable because of discord or conflict of personalities between yourself and your husband that destroys the legitimate ends of the marriage relationship. Is that correct?
Yes, ma'am.
Is there any reasonable expectation for reconciliation?
No, ma'am.
And you and your husband do not have any minor children. Is that correct?
We do have one minor child. She's at the age of 17.
And is she still in high school?
She's still in high school. I am currently not seeking child support. All I'm asking for is for my husband to continue paying for our medical, dental, and vision.
Okay, it's because your petition doesn't name her. And so are you asking for a trial amendment at this time?
No.
Well, because you need to name her on your petition. And so you don't have her named on this petition.
Okay.
So technically, you have to have her name on here. So, I mean, I'm asking if you want a trial amendment, if you're asking for a trial amendment at this time, so you can add your minor child to this divorce petition, I can allow you to do that.
Okay.
Yes, Your Honor. She's gonna need one.
Okay.
Um, and I'm not trying to speak on her behalf, but I don't think she understands which.
Okay, so the trial amendment, in other words, you need to add it prior, you need to add the child's name to it. Now, the other thing though that I did notice that was brought to my attention, Ms. Sainz Salinas, is that Mr. Salinas executed a waiver of service prior to the original petition for divorce. So I cannot accept his waiver of service because his waiver of service needs to be dated after the petition for divorce. However, Mr. Salinas, because you have had an opportunity to review the original petition for divorce and are noticed of these proceedings, you can waive on the record any personal service. Are you waiving that at this time?
Yes, Your Honor, I am waiving.
Okay.
Ms. are in total agreement of all
Okay.
relations.
So then, Ms. Sainz Salinas, I will accept your request for a trial amendment. And can you please state your minor daughter's name for the record?
Sure, her name is Abby, Abbie, Gail, Gael, Salinas.
Okay, and her date of birth, ma'am.
It's 7/21/2004.
And she is a female that is a minor, is that correct?
That is correct.
Okay. Now, as to your daughter, you are not asking for any child support, is that correct?
That is correct.
And Mr. Salinas will be responsible for her health insurance?
That is correct.
That's correct, Your Honor.
Okay, so then any out-of-pocket expenses, will those be divided 50-50?
I will take care of those.
Okay, so then you will be responsible for 100% of the out-of-pocket medical expenses?
That is correct.
Okay. And what about visitation? Will visitation be my mutual agreement when the child is available?
Mutual agreement. My husband will have full access to my daughter.
Okay. So then, and that will also be the same for holidays, is that correct?
That is correct.
All right. And what about division of community property? What is the agreement that you all have entered into, Ms. Salinas?
The only thing that we own together is our home. And my husband has agreed that I would keep the house since I still have the child.
Okay, so then will you be keeping the house permanently?
Yes, ma'am.
Now, does that mean that you're also keeping all the equity in the home?
Yes, ma'am.
Okay, and Mr. Salinas, is this your agreement, sir?
Yes, ma'am.
Okay, and how about retirement accounts? Are each of you keeping your own retirement accounts?
We are keeping our each own retirement account. Yes, ma'am.
And are each of you keeping your own bank accounts?
Yes, ma'am.
Okay. What about debt?
We're responsible for our own debt.
Okay, so each of you will be responsible for any debt that is in your sole name and incurred by you. Is that correct?
That is correct.
All right. Okay, so everything that you have testified to on the record needs to be put forth in a divorce decree, okay? So I'm gonna give you some time to put that divorce decree together.
Okay. So if I already have a divorce decree drawn up that state, when I came in to file for the court, I brought the divorce decree with me and I showed it. And everything we just stated is on here.
Okay, as long as Mr. Salinas' signature is on it.
Okay.
And everything that you have put on the record is on there, you can file that divorce decree.
Okay.
And Ms. Sainz Salinas, are you requesting a name change?
Yes, ma'am.
Okay, so that has to be on there too. So you're requesting to return back to Sainz?
That is correct, ma'am.
Okay. Okay, anything else that we haven't covered?
Not on my part, Judge.
Okay. All right, then the court will accept the agreement as testified to onto the record. And we'll go ahead and grant your divorce today. And I'm gonna go ahead and give you 30 days to submit that divorce decree. So I'm going to set a tickler for November the 12th. And that's just a reminder for me. You do not appear. I'm just gonna look to see that you turned in that divorce decree.
Okay.
Okay,
The divorce decree, I sign it, he has to sign it, and then I file it with your court.
correct.
Okay.
All right. Well, I wish you all the best of luck.
Thank you.
Okay.
Thank you, Your
for
Honor.
your patience.
Thank you.
Appreciate your
Thank you for
time.
your time.
You're welcome. Okay, Mr. Mancha Guerra.
Buenas tardes, señoría.
Okay, so that's F 1062-21-9 in the matter of the marriage of Erica Mancha and Juan Mancha Guerra. Is Erica Mancha present?
No creo que esté presente.
I don't think she's present.
Okay, can you ask Mr. Mancha Guerra if he has had any contact with her?
Mr. Guerra, ¿ha tenido usted contacto con la señora Mancha?
Sí, apenas en la mañana me pasaron el número de Zoom y se lo pasé a ella, pero dijo que tenía trabajo, a lo mejor no podía meterse.
This morning, they provided me the Zoom info and I gave it to her, but she said she was working and probably didn't have time to log on.
Okay, let him know that then he'll return, they'll have to return on November the 10th. Both of them have to be here.
Okay, entonces, tiene que regresar el día 10 de noviembre. Los dos tienen que estar presentes.
Es que es la segunda vez que pasa y pues yo quisiera ya terminar esto, estamos los dos de acuerdo y no tenemos ni una, pues nada, está todo firmado y todo, no sé si pudiera hacer algo.
This is the second time this happens. We don't have anything. Is there anything we can do?
No, because he did not file a counter petition. So I cannot take it up unless the petitioner is present.
Okay. No, pero usted no metió contrademanda, so no podemos procedir si no está la que pidió la demanda.
Y si trato de localizarla ahorita mientras sigue el corte, no pudiera hacer algo.
And if I try to locate her while the court's still on?
He can have her log in as long as we're on.
Usted puede tratar de localizarla, pero si todavía estamos aquí presente.
Ok, muy bien, déjeme tratar de localizarla.
I'm going to try to localize her.
Okay. Attorney Carlos Escobar.
I'm here, Your Honor.
Okay, thank you for your patience, gentlemen. Okay, what number are we on the court's docket?
Number 14, Your Honor.
Okay, that's CL 175205-I, Christina Esparza versus Edinburgh CISD.
Good morning, Your Honor. Eddie Garza here on behalf of the defendant.
Okay, and is Mr. Ruiz still on this case?
Yes, good morning, Your Honor. Yes, but Mr. Escobar will be handling the argument.
Okay. And then, all right, let me just check if Ms. Herrera has a quick announcement, and if not, I'm going to take you all up and Ms. Orellana and Ms. Sandoval on there. They have the same motion you all have on another case. Okay, Ms. Herrera, do you have a quick announcement?
Probably quicker. I'm here on number 16 on the court civil docket representing CL Moto. It's our MSJ. Just need to prove it up on the record, Your Honor.
Oh, that's right. Okay. CL 193234-I, CL Moto versus Lucio de los Santos. Mr. Damian, please call out Mr. de los Santos' name 3 times.
Yes, ma'am. Lucio de los Santos. Lucio de los Santos. Lucio de los Santos.
Okay, the name being called out 3 times. And go ahead, Ms. Herrera.
Thank you, Your Honor. Again, my name is Elizabeth Herrera. I'm here representing plaintiff CL Moto Finance. We are here on our motion for a summary judgment. I would first ask the court to please take judicial notice of the items in the court's file, and I move to admit the exhibits previously tendered to the court. These were Exhibit A, the notice or the note and security agreement, Exhibit B, certificate of title, Exhibit C, default letter. Exhibit D, plaintiff's written discovery to defendant. Exhibit E, the declaration of Tammy Jean Pelizzaro. And Exhibit F, the declaration of Savannah Barlow, as well as a supplemental affidavit filed with the court September 22nd in support of attorney's fees.
Okay, the court will take judicial notice of all the documents in the court's file, specifically that the defendant was also properly noticed. No response to the motion for summary judgment was filed. The court will also admit exhibits A, B, C, D, E, F, and the supplemental affidavit as to the attorney's fees. Okay, you may proceed, Ms. Herrera.
Thank you, Your Honor. On May 24th, 2018, the defendant Lucio de los Santos executed the note and security agreement, a copy of which has been tendered to the court and admitted as Exhibit A. This was to secure payment of $27,000 or $27,027.36 as purchase price for a 2018 Viking 21 FQS travel trailer, and granted to Ron Hoover Company of Donna Incorporated a security interest in that collateral. Frost Financing Incorporated then purchased defendant's loan from Ron Hoover Company of Donna Incorporated and became the lien holder under that note and security agreement. Frost's lien is noted on the certificate of title, which has been admitted as Exhibit B. On August 24th, 2018, plaintiff CL Moto purchased the note and security agreement from Frost. The note and security agreement required defendant to pay $375.38 on the 23rd day of each month, and provided that he would be in default if he failed to make those payments, which he did. So defendant failed to continue making those payments beginning in October of 2018. The note and security agreement admitted as Exhibit A provided that all amounts payable may be accelerated at the lender's option in the event of borrower's default, and lender would be entitled to legal expenses, costs, and fees incurred in collecting under the note and security agreement. On June 21st of 2019, plaintiff notified defendant of his breach. A copy of that default notice letter has been admitted as Exhibit C. On June 11th of 2019, plaintiff filed this lawsuit asserting claims for breach of promissory note, foreclosure of its security interest in the collateral. We also filed an application for writ of sequestration, seeking to repossess that collateral during the pendency of this lawsuit. That application was granted and the collateral was successfully repossessed back in August of 2019. The defendant, as Your Honor noted, failed to file a formal answer in this lawsuit. He did otherwise appear. He failed to respond to plaintiff's request for production, interrogatories, request for admission, and all of the discovery that was served in this case on September 24th of 2019. Copies of those discovery requests were also admitted for purposes of this hearing as Exhibit D. Right now, the amount of $17,884.43 in principal, interest, and late fees is due and owing on the note and security agreement. Plaintiff is also entitled to recovery of reasonable attorney's fees in the amount of $10,761.67 and costs in the amount of $651.80. Pursuant to the terms of that note and security agreement and under section 38.001 of the Texas Civil Practice and Remedies Code, because the lender's claim is for recovery on an oral or written contract, the lender did previously make demand on plaintiff, and now much more than 30 days have lapsed since that demand was made. So at this time, Your Honor, I would ask that the court consider the information and arguments contained in plaintiff's motion for summary judgment, grant plaintiff's motion, and issue an award to plaintiff of $17,884.43 in actual damages, granting possession of the collateral to the lender for the sale of that collateral, with the proceeds to be applied toward the amount owed by defendant, and also award plaintiff the attorney's fees incurred in the prosecution of this lawsuit, as well as costs and pre-judgment and post-judgment interest at the highest rate allowed under the law. Thank you.
Okay. The court will grant the relief as requested and put it on the record. Is there an order on file?
I believe that there is an order on file from long ago. What I'm going to do is submit an amended order or a new proposed order that does include the total amount of those attorney's fees.
Okay, just make sure that you indicate that it's amended so that that's the one that's forwarded to my queue.
Yes, Your Honor, we will do that.
Okay, and how much time do you need to do that?
We can get that on file by the end of the week.
Okay, I'll go ahead and just set a tickler for October the 22nd.
All right, that's all I had. Your Honor, may I be excused?
Yes, you may. Thank you, Ms. Herrera. Okay, so let me go ahead and recall CL 175205-I, Christina Esparza versus Edinburgh CISD. Go ahead, gentlemen.
Good afternoon, Your Honor. This is Eddie Gatz on behalf of the defendant. It's our motion. May I proceed?
Yes, you may.
Okay, thank you, Your Honor. Essentially, this is a plea to jurisdiction filed by the defendant, Edinburgh CISD. Your Honor, the plaintiff is a former assistant principal of a middle school of the district, and there came to be discovery that she had taken a picture, a selfie of herself. It was a nude photograph. It somehow got disseminated out into public to where over social media and through networks. So therefore, students of the school saw it, staff members saw it, there was news coverage about it. This district got complaints about it. What it led to eventually was the termination of employment of this particular administrator at the school. Now, after that employee was terminated, she challenged the termination of her contract through the Commissioner of Education. So she went through an administrative process. In that challenge, the Commissioner of Education determined that the photo diminished her capacity to perform her role as a principal, and they therefore affirmed the school board's decision to terminate her. Now, after the commissioner did that, the plaintiff sought judicial review of that Commissioner of Education decision. They did that in district court there in Hidalgo County. So they pursued that. The district court in Hidalgo County reversed the Commissioner of Education's decision. Shortly after that, Edinburgh and the Commissioner of Education appealed that to the 13th Court of Appeals there in Edinburgh. The Court of Appeals reversed the district court and upheld the Commissioner of Education's decision. So after a lengthy process, what happened was the 13th Court of Appeals determined that the termination of employment was proper and that there was no reason to overturn it. So the Commissioner of Education's approval of that particular termination was going to stand. Essentially, the decision upheld the decision to terminate. It said it was supported by substantial evidence. It was not erroneous, and that Edinburgh CISD's decision to terminate was not arbitrary, capricious, or unlawful. Now, subsequent to that happening, literally the 13th Court of Appeals issued an opinion, published an opinion. Now, normally in situations where we have these claims, discrimination claims, we, at the trial court level, we don't know what the 13th Court of Appeals will do after a trial or after a dispositive motion is granted. We have to, try our matter here at the trial court and then determine. But in this set of circumstances, the 13th Court of Appeals has already issued an opinion and made some rulings and findings that are binding on this court. Now, the district court level or the court level that we're at here is not a court of review of the 13th. It's the other way around. The 13th reviews decisions made down at the Hidalgo County level. So essentially, the determination of her employment has been judicially determined to be proper. And so the claim that is before you here in this case, this is kind of like parallel to the administrative proceeding, is that the plaintiff claims that her termination was unlawful in that it was a violation of the Texas Labor Code in the form of gender discrimination. So what the plaintiffs are saying is, well, we haven't tried a case on gender discrimination. I'm sorry. We tried the administrative proceeding regarding the termination at issue, where the reason this court lacks jurisdiction to hear any claims further in this regard is because the 13th Court of Appeals has already made a judicial determination that cannot be undone, that has already been established, that the rationale, reasoning, evidence behind the termination was non-discriminatory, legal, rational, and normal. Now, what the plaintiffs have articulated is, well, normally under the balance shifting format of a discrimination claim, the plaintiff would make an allegation and the defendant would articulate a legitimate non-discriminatory reason, thereby allowing the plaintiff to come back and say that it's a pretext or rebut it. In those situations, we're talking about assertions or allegations or essentially making the case that there is a legitimate non-discriminatory reason. This case is a little different. The 13th Court of Appeals has already determined that it was legitimate, non-discriminatory, a proper termination. It's not that we articulated it and we need to find out if it is or is not. This was actually a determination made by the 13th. So essentially, the most pertinent matter that could possibly be raised in this case has already been established and can't be undone. Now, there's a case on point, and it's actually out of the 13th Court of Appeals. It's called Point Isabel School District versus Hernandez. It's almost virtually identical, not identical, but it's virtually identical. The plaintiff challenged a non-renewal with the Commissioner of Education, and they lost. She then appealed to the district court, which upheld the decision. Afterwards, she filed a complaint with the TWC for age discrimination and retaliation, and the 13th Court of Appeals decided that trial court lacked jurisdiction to hear the plaintiff's claims. So we're talking about going down the exact same path that has already been done once before, at least in the 13th Court of Appeals, where this case would lie. The 13th has already issued an opinion. We attached it as an exhibit to the pleaded jurisdiction for the court's review. And of course, that's a published opinion, and the court can take that into consideration. So while I recognize that the counsel for the plaintiffs have really done quite a creative and a good job of advocating for their clients in this regard, they fully litigated this matter and had an opportunity to fully litigate this matter in the original proceeding. In that original proceeding, Your Honor, they had discovery that took place before hearing. They had a full-blown hearing. They had depositions. They were represented by counsel. They had an examination hearing with live testimony of like 6 witnesses. The plaintiff filed a motion for summary judgment, a motion to exclude evidence, a motion to dismiss. This matter has been fully litigated before. But even aside from that opportunity to litigate, the most crucial factor here that cannot be undone is that the 13th Court of Appeals has already judicially determined that this termination was proper. You can't challenge it again for whatever reason you want, because if it gets from this court here, if we're able to go forward here, if the court recognizes jurisdiction and we go forward, it gets to the Court of Appeals, and the Court of Appeals says, well, we already determined this, already made this issue. So what we're saying in our plea is that the decision's already been made, the decision's been done. We have to live with that decision that was made. It was not appealed beyond the 13th Court of Appeals. I think the writ was denied. So it's that decision is final. What's attached in response to our plea. So therefore, we're saying, because of what's already transpired, because of the rulings of the 13th Court of Appeals, this matter, the court has no jurisdiction to hear the continued complaints of the plaintiff trying to challenge that same termination in the form of a gender discrimination claim. So therefore, we'd ask that our pleaded jurisdiction be granted because the court lacks jurisdiction in light of the 13th Court of Appeals findings.
Okay, Mr. Escobar, your response?
Yes, Your Honor. Let me start. I'm going to do a general to specific kind of view on this case. What I think is happening here, Your Honor, is that there may be some confusion with respect to a res judicata versus a collateral estoppel argument. And so as the court knows, Your Honor, res judicata says that if you bring a lawsuit, you have to bring, and you get a judgment on a lawsuit. Res judicata bars not only the claim that was actually litigated, but any and all claims that could have been litigated at the same time. So res judicata says, look, if you have any actionable claims and you're going to bring those claims for whatever reason, you have to bring all that you've got. And if you don't have that, then you're barred as a matter of law. That's res judicata. That is not what Edinburgh ISD is asserting. What they're asserting is collateral estoppel. Collateral estoppel deals with the particular issues that were tried and fully litigated. So collateral estoppel only applies to the things that were actually litigated, as opposed to res judicata that says you're barred from bringing anything that was tried and anything that you could have brought at the time. Okay, so again, Edinburgh ISD is not arguing res judicata, they're arguing collateral estoppel. And that is the distinction, because the claim that was litigated was whether or not Edinburgh ISD had good cause to terminate her contract. That was the claim. Do they have good cause? So that was litigated all the way up to the 13th, and the 13th says, for their ruling has it's implicitly say, well, Edinburgh ISD had good cause to terminate the contract. That is not the claim that we're bringing before the court. We have a gender discrimination claim, Your Honor. And the gender discrimination claims is that, like any gender discrimination claim, Mrs. Esparza, because she's female, is asserting that similarly situated male ECISD employees were not treated the same as she was. So in other words, she's alleging in her lawsuit, and she's made the allegations in her pleadings, that similarly situated male ECISD employees who violated ECISD policy were not terminated as she was. Okay. And so what we need to look at, Your Honor, is the specific issue. So there was no specific issue in the underlying case and in the underlying appeal that made a determination as to whether or not similarly situated male ECISD employees who violated ECISD policy were terminated or not terminated. That issue was not at issue in the prior litigation, nor could it be, because that claim wasn't brought. And so that's why that's the distinction that you have to make, Your Honor, because what Mr. Garza is asserting on behalf of Edinburgh is that collateral estoppel means that this issue was tried. And he said it a couple times, and I need to make the record clear. What Mr. Garza said was that the 13th Court of Appeals said that the termination was for good cause. And he says, he added in there that it was a non-discriminatory basis. Okay, that's not true. The 13th Court of Appeals, in their opinion, never says that they fired her because they had good cause and there was no discriminating reasons a part of it, as part of this termination. And so let me just cut to the chase and clear this up for you, Your Honor. Here's what the problem is that Edinburgh and Mr. Garza have. The gender discrimination claim that Ms. Esparza is asserting has to be reviewed under the McDonnell-Douglas framework. And I'm just going to go through it so the court can understand where I'm going to. And then I'm going to read the punchline or what you need to know, but I'm just going to go through it, Your Honor. It says, to establish a prima facie case of employment discrimination, the plaintiff must show that he was a member of the protected class, that he was qualified for his employment, that he was subject to an adverse employment decision, and he was replaced by someone outside of the protected class, or he was treated less favorably than similarly situated persons of the opposite class. That's a disparate treatment claim. Once the plaintiff has established the prima facie case, the burden shifts to the defendant to show that the employee was terminated for a legitimate, non-discriminatory purpose. It continues. If the defendant proffers a legitimate reason for the adverse employment decision, the burden shifts back to the plaintiff to show either one, the reason stated by the employer was a pretext for discrimination, or two, which is what I'm going to assert to the court today, Your Honor. Two, the defendant's reason, while true, was only one reason for its conduct, and discrimination is another motivating factor. That is the mixed motive McDonnell-Douglas standard. Again, it says if the defendant proffers a legitimate reason for the adverse employment decision, the burden shifts back to the plaintiff to show either one or two. The defendant's reason, while true, was only one reason for its conduct, and discrimination is another motivating factor. So just because the 13th Court of Appeals says that ECISD had a legitimate reason, it does not preclude Mrs. Esparza's claim for gender discrimination, because she can show the mixed motive McDonnell-Douglas claim, which is that there was a discriminatory reason for the termination. And so this leads me to my next point, Your Honor, which is probably the best one, which is this. In a plea to the jurisdiction, the court must take as true all of the allegations pled by the plaintiff. That's City of Ingleside versus City of Corpus Christi, 469 Southwest 3rd, 589. That's a Supreme Court of Texas case 2015. So what that says is this, Your Honor. It says in a plea to the jurisdiction, you have to take what the plaintiff pled is true. And this is what she pled. This is what Mrs. Esparza pled. She's pled that she was a female, part of a protected class, that she was qualified for her position, that she was terminated, that she had exhausted her administrative remedies, that similarly situated male ECISD employees who violated policy were not terminated as she was, and that ECISD's termination of Mrs. Esparza was motivated by unlawful gender discrimination. And so once we make those allegations, it is on the district to rebut those allegations if they bring a fact-based plea to the jurisdiction. They never rebutted any of those facts. And because they never rebutted any of those facts, the court must take those facts as true. All they did, that Edinburgh did was submit the evidence in the underlying case, which was a breach of contract, a contractual Chapter 21 case under the Education Code to determine whether there was good cause or not. It has nothing to do with gender discrimination. And it has nothing to do or there's no showing that any of these elements that I just mentioned, which is her prima facie case of discrimination, nothing that they submitted rebuts any of these facts. So if they didn't rebut these facts and Mrs. Esparza pled these facts, then you can't dismiss this case, Your Honor, based on a lack of jurisdiction, because the TCHRA allows a gender discrimination claim. There is a waiver of immunity for that. We pled under that waiver. And because of that, Your Honor, the court should deny the plea to the jurisdiction. I think in a nutshell, Your Honor, that's it. I mean, there's nothing that Edinburgh has done to negate or rebut any of the facts that we've asserted. And under the McDonnell-Douglas framework, even if we agree that their reasoning was a legitimate reason, because again, it says this, it says the defendant's reason, while true, was only one reason for its conduct, and discrimination is another motivating factor for the termination. And so under the law, Your Honor, even if I agree with Mr. Garza, which I respectfully disagree with him, but even if I agreed with him, even if you found that that's a legitimate reason, even if I am stopped collaterally on this issue, whether they had a legitimate reason or not, you still can't dismiss this case because Mrs. Esparza made the proper factual pleading. Edinburgh ISD did not rebut it, and McDonnell-Douglas allows Cristina Esparza to continue with her claim. That's all I have, Your Honor.
If I may add something, Carlos, real quick. Your Honor, the McDonnell-Douglas test is from the United States Supreme Court. It is probably the most cited case in employment discrimination cases, which have to be proved circumstantially. And that's all I wanted to clarify for the court at this point, Your Honor.
May I respond, Your Honor?
Yes.
Your Honor, I guess if you follow the logic that was just explained to you from plaintiff's counsel, if the termination at issue was lawful, they would have no claim. If the termination was unlawful, then perhaps they would potentially have a claim. I heard them talk about good cause, and then they said that, well, it's discriminatory. So you could have something that is purportedly good cause that is also discriminatory, which would be completely an oxymoron in and of itself. But if the issue of whether or not the termination was lawful, the term is pertinent to jurisdiction, then you need to look at what the 13th Court of Appeals said, which the issue, the collateral estoppel issue, was whether or not that termination was lawful. And they've already determined it. They're not going to reverse themselves because the plaintiffs want another bite at the apple and want to pursue an alternative type claim because they lost at the appellate level and the district court level on these issues, had an opportunity to litigate all these matters, challenged it in any way, shape, or form they wished. And the 13th Court of Appeals opinion, it kind of speaks for itself, Your Honor, but it essentially says that that decision is supported by substantial evidence. It's not erroneous. It's lawful. It's so to say that, well, there can be unlawful gender discrimination. Well, you can't have a finding like that if the Court of Appeals has already determined that the termination was lawful. So if the Court of Appeals had felt that there was a fact issue or there was something that was improper about the grounds for termination, and they wouldn't have determined that the matter was lawful or unlawful. But irrespective of what they did or how they did it, they've already made a ruling. And under the doctrine of stare decisis, we have to follow that. So what the plaintiffs are asking you to do is to deny this plea of jurisdiction, which would be interlocutorly taken up to the Court of Appeals. to discuss the very case and the very record that they've already ruled on, that they've already issued opinion on, that's in the court's possession attached to it, and that is substantially similar to a 2019 Port Isabel Independent School District case that they've already ruled on as well. That we already know what the 13th court will do and what they've done in the past. So we're asking, and I completely respect the advocacy on behalf of the plaintiffs, and they're doing a great job on behalf of their clients, but they're kind of stuck behind the 8 ball because the Court of Appeals has already issued a ruling, has already issued termination. Normally, we don't do that. So even if you apply McDonnell Douglas in there, McDonnell Douglas doesn't take into account any one of those factors that is judicially admitted. Those are things that you have to prove and support your claim, and the defendant has to support his. But when one of those elements is judicially admitted, such as, there is no unlawful gender discrimination because the termination was lawful, the analysis ends there. So I would ask this court to respectfully to deny this plea to jurisdiction, because I think the Court of Appeals has already clearly advised us on how they would rule on this matter or what they would do with it. And I think that because of what happened at that level, this court is without jurisdiction to hear this claim.
Okay, anything else?
No, Your Honor.
All right, do you all have your orders on file?
Your Honor, I will be filing an order denying the second plea to the jurisdiction because this is the second plea to the jurisdiction that Edinburgh ISD has filed. We've already gone up to the 13th in this case on
a different issue, a completely different issue.
On another issue, Your Honor. But again, I mean, if we were to argue law of the case like Mr. Garza is arguing, they've already, the trial court had already denied the first plea to the jurisdiction. So then the court should deny the second one, but they are different. And that's the distinction I'm trying
apples
to
and oranges. Apples and oranges. That has absolutely nothing to do with a ruling by the 13th Court of Appeals that's already been put in place. The first one was a administrative remedies challenge with respect to statute of limitations. It had nothing to do with the claim that's before the court today.
Mr. Garza just proved my point, Your Honor. That's exactly what I'm trying to say about this particular issue.
Okay, so go ahead and have your orders filed, and I'm going to take this under advisement, and I'll issue a ruling soon, and then you'll get notice of that ruling.
Thank you. We'll submit a new proposed order for the court, so it'll be fresh in your queue.
Okay, that's fine. All right. Thank you, gentlemen. You may be
Thank you,
excused.
Thank you. Have a great day.
Okay, Miss Loriana and Miss Sandoval, I'll take you up. Give me a quick, just have a quick 2-minute break, please, okay? Sorry for keeping y'all hanging on. All right. We're off the record for just a quick 2 minutes. Okay, thank you. Let me just make sure my court reporter's ready.
First judge ready.
All right, we're back on the record. Can you give me again what number on the docket it is?
It's number 39, Your Honor.
Okay, thank you. So I'm gonna recall CL 20-2188-I, Jeronimo Ibarra Flores versus the City of Alamo. Okay, Ms. Sandoval, this is your motion?
Yes, Your Honor. Rose Sandoval on behalf of the City of Alamo. This is our plea to the jurisdiction. This is different than the last plea to the jurisdiction. This does not involve an employment case. This is actually an automobile accident case between an City of Alamo police vehicle and the plaintiff's vehicle. And this accident happened when the officer was responding to a call of a woman being assaulted. He was on his way to the scene of the accident or the assault when he crossed an intersection. He had turned on his lights and sirens prior to getting into the intersection. He noted that traffic from I always get these mixed up, that was going northbound in the first lane was stopping. A car was turning, but traffic behind that was stopping. And then he noticed traffic from the southbound direction on Alamo Road was stopping, and he proceeded, but unfortunately the plaintiff was in the outside lane going north, and there was a collision in the intersection. Actually, both Ms. Oriana and I have, I think, filed the exact same documents and evidence, the video, the deposition testimony concerning this accident. And because this is a car accident involving a police vehicle, and the City of Alamo is the employer of the police officer, the City of Alamo is a governmental entity. And so in order to sue a governmental entity, you have to show a waiver of immunity for the court to have jurisdiction. And so the Tort Claims Act does provide for waiver of immunity for claims arising out of automobile accidents. However, there are exceptions to that rule. And one of those exceptions is called the emergency exception, and it's contained in section 101.055 of the Tort Claims Act. And it specifically says that the chapter, the waiver of immunity, does not apply to claims arising from the action of an employee responding to an emergency call or reacting to an emergency situation if the action is taken in compliance with the laws and ordinances applicable to the emergency action, or if the action is not taken with conscious indifference or reckless disregard for the safety of others. There are a couple laws in the Texas Transportation Code that apply to this situation. The one is 546.001 of the Texas Transportation Code, which sets forth the permissible conduct of emergency vehicles. And that statute basically says that an emergency vehicle operator can proceed past a red stop and go signal light after slowing as necessary for safe operation. The second provision of the Transportation Code is 546.005, and it applies to due care. And it says that the operator of an authorized emergency vehicle is not relieved of responsibility if his actions are taken with reckless disregard for the safety of others. And so these are the issues that are in dispute here, is essentially the reckless disregard, whether there was conscious disregard. So a plaintiff can raise a fact issue on whether this provision, the emergency exception, applies in a couple of ways. First is they can say, oh, well, they weren't responding to an emergency. Well, or Officer Bettis, the City of Alamo police officer, was responding to an assault in progress, and that's an emergency. I haven't seen any case cited for the proposition that it's not. And under the law, the term emergency, or what constitutes an emergency, is interpreted broadly. It's any circumstances that call for action. And a person or woman getting beaten up would qualify for an emergency situation. I believe the plaintiff's position is that the officer did not have his lights and sirens on constantly. He only activated them as he approached intersections. Well, that would be appropriate and in compliance with the law that I just mentioned to you, 546.001 and 546.005 of the Transportation Code. And the only people who can proceed past, or typically can proceed past, red stop and go lights are people who are responding to emergencies, who are authorized personnel such as police officers. So Officer Bettis was exercising his discretion in getting to the scene of this emergency as safely as possible, not driving like a maniac 60 miles per hour down the road. So how else can you raise a fact issue? So we don't believe there's any fact issue on whether an emergency situation existed. How else can you raise a fact issue? Well, you can argue that it was not in compliance with the laws controlling emergency actions. And as I just mentioned, the law is that if you slow as you approach an intersection and then proceed, that's permissible. That's what the law allows. And there is a video, and I know it's been presented in the court's file, and I know that court will take the opportunity to review that, as well as all the deposition testimony that we've presented. But I guess that brings me to the final point, which is, I guess, the key primarily disputed issue is that a plaintiff can establish that there is no waiver if they can show that the officer's actions were taken with conscious indifference or reckless disregard. So what is conscious indifference? Well, it's more than just a momentary lapse. It requires proof that the individual knew their conduct posed a high degree of risk or serious injury and simply didn't care. It's different and higher burden than negligence. You need to show awareness that what you're doing is wrong. Basically, that you knew blast through the intersection, go in 50 miles per hour without attempting to do so safely. And that's not what occurred here. It's simply not the case in this situation. Officer Bettis slowed down as he got to the intersection. He had his lights and sirens on. He saw southbound, which is the opposite lane from the direction that Mr. Flores was traveling, stopping. He started to slowly move into the intersection. And again, he perceived it was clear to cross, but unfortunately the accident occurred. These factors, these points that I'm making negate conscious indifference. I think one of the arguments is that, well, he didn't have his lights on long enough. That was too close to the intersection or time of the accident. But clearly they were on long enough, particularly for that southbound traffic, the traffic going the opposite direction, to notice. I think the other point that I've heard is that, well, you know, his vision was blocked. Officer Bettis, as he entered the intersection, he couldn't see absolutely everything. Well, there's multiple cases, Your Honor, that hold that actions similar to what Officer Bettis did in this case negate conscious indifference. I've cited many in our brief, and if the court wants, we can submit these cases. I don't know if you have access to review them, but for instance, the Texas Department of Safety versus Sparks. This is a case out of the 13th Court of Appeals, 347 Southwest 3rd, 834. Court said obstructed view does not rise to the level of recklessness. Harris County v. Spears, 2018, Westlaw 4571841. The visibility was obstructed, but the officer was taking precautions, as Officer Bettis was in this case. So there was no conscious indifference. Pasadena versus Kuhn, another case, 260 Southwest 3rd, 93. The officer was proceeding slowly after he had stopped at the intersection, but nonetheless, unfortunately, an accident occurred. The cases where the courts have found that a fact issue is created are situations where they, for instance, did not have on lights and sirens. or there might be a dispute about whether they were even on, or the officer or emergency worker, ambulance, police, fire, whoever it may have been, was traveling at an excessive rate of speed. And none of these are factors or issues in this case. Throughout the whole emergency call, Officer Bettis showed deliberate awareness to proceed cautiously but quickly and in accordance with the law. So the emergency exception applies and immunity is not waived in this case. We also asserted that the officer is entitled to official immunity because he was proceeding in good faith without conscious indifference. And again, basically everything that's shown here shows that he was not consciously indifferent. And so that in a nutshell is the situation. We have presented the depots, the video, and I can submit the case law if the court prefers, but we're asking the court to grant the plea to the jurisdiction.
Okay, Ms. Orellana, your response?
Thank you, Judge. Just to clarify on the facts of the case, my client is in fact traveling northbound. However, he is traveling on the inside lane or the left lane. He's not on the outside lane, which does make a difference. So just to clarify that. As to whether the Officer Perez was acting in an emergent manner, I think is up for dispute. In his deposition, Officer Perez does state that his emergency lights would be activated only upon reaching an intersection and when he was in the process of crossing that intersection. I don't know about the sirens, and I know my client is saying that the siren was not on. Officer Perez is saying that they weren't on. That one's going to be a he said, she said, simply because even the video, the Walgreens surveillance video that we have doesn't have any sound. So that's going to be up for dispute as well. But as to the emergency lights, in his deposition, the officer also stated that he turned on the lights about a block before he reached the intersection where this accident happened. And the video clearly shows that the lights were not on a block before this intersection where the accident happened. In fact, the lights, Officer Perez turned on his emergency lights only 5 seconds prior to the accident happening. Southbound traffic does stop because they have a clear view of the officer. The northbound traffic, the vehicle, there's a minivan style vehicle driving on the outside lane or the right lane. He or she is making a right-hand turn. So he slows down and makes his right-hand turn. My client is traveling in the inside lane or the left lane, traveling northbound and doesn't see the officer. So we disagree and of course call into question whether the situation was an emergency or not that Officer Perez was responding to. As far as the reckless disregard for the safety of others, the plaintiff, of course, must show that the operator committed an act that, in this case, Officer Perez knew or should have known posed a high degree of risk of serious injury. In this particular case, Officer Perez also testified in his deposition that he was aware this was a highly trafficked intersection. He knew it was a busy intersection. I believe the police department is less than a mile away from this intersection, so he's familiar with the intersection. He goes on to testify that the discretionary use of the emergency lights, that each officer, of course, has the discretion to determine when the lights are used or not. In this particular case, he states that he was only turning on his emergency lights in between when reaching each intersection because there tends to be complaints from the community about the sound of the sirens, about police officers speeding through the neighborhood, about the lights, and he deferred to those complaints rather than the other drivers on the roadways, knowing that if it's true that he was answering this emergency call, his lights should have been turned on the moment that he decided to answer this call, and he got into his patrol unit to travel to this area where the dispute was happening. But he doesn't. He only turns it on in between or when crossing intersections, and only 5 seconds prior to the accident happened. My client is traveling in a truck and he's pulling a small trailer. He did food for events and he's pulling a trailer. 5 seconds was certainly not enough notice to allow my client, even had my client seen the emergency lights, to have stopped prior to the accident occurring. So in effect, we believe that the officer should have had his lights to ensure the safety of all other drivers on the roadway, to put them on notice that Officer Perez was not going to adhere to these traffic laws because he was answering this emergency call according to some of his deposition. So we are arguing that, of course, the immunity is waived in this case, and that his actions don't show that he was responding to an emergency situation and that he was acting in a reckless disregard for the safety of others on the roadway. And the last point is that we feel that the fact that the emergency lights only became an active element in these 5 seconds prior to the collision happening, that's the emergency status of defendant's vehicle is more of a matter of fact. It's a question for the jury to determine whether that was sufficient notice for my client to have stopped and attempted to avoid this auto accident that happened. So we are asking the court to deny defendant's plea to the jurisdiction in this matter.
Okay, any reply, Ms. Sandoval?
I think, just Your Honor, that I would simply point out that I think that the conscious disregard is completely negated by the video. So I think the court needs to review that themselves to see how the officer is proceeding. Yes, an accident occurred. I don't dispute that Mr. Flores could not see the vehicle, but that's not the issue. I mean, we do have an accident here. We understand how it happened, but the issue is the officer's action and whether he was consciously or recklessly proceeding, which he was not. And as I said, if the court, the cases that I've cited pretty much all point that out as how this area of the law works. So if the court wants me to submit that, I will. Otherwise, we're asking the court to grant our plea to the jurisdiction.
Okay. So
may I respond to that bit real quick?
Okay.
The Officer Perez does admit in his deposition that he couldn't see the traffic in the inside lane or this left lane where my client was traveling in. And despite not being able to see whether there was a vehicle coming or not, he still decided to go into the intersection despite not knowing whether traffic was coming in that lane of travel or not, just to add that.
And that's why the cases say, Kuhn in particular, that they may enter into a blind intersection. And that is why the statute provides that emergency vehicle may proceed through a stop after slowing is necessary. And that's what happened here.
Okay. So then, if there's anything else that you want me to look at in making my decision that's written, such as the case law or anything, then have that submitted to me by, it's Friday enough time?
Yes, Your Honor, I'll just submit the cases that I've cited to the court.
Okay, Ms. Orellana, if there's anything that you want me to also look at in addition to your arguments, just have them submitted by Friday. And then do you all have your orders on file?
I believe so, or we'll check.
Okay.
Yes, Your Honor.
All right, so go ahead and get your orders on file, and I'm gonna take this under advisement, and I'll issue a ruling probably in about 2 to 3 weeks.
All right.
Okay, Judge.
Okay,
Your
anything
Honor.
else?
No, that's it.
Okay, thank you for your patience.
Thank you, Judge. Have a good day.
Likewise. Okay, I'm gonna recall F1062-21-9 in the matter of the marriage of Erica Mancha and Juan Mancha Guerra. Ms. Castañeda, can you please ask Ms. Mancha to turn on her camera? I believe she's Spanish speaking.
Erika Mancha, por favor, prenda su cámara.
Ay, es que estoy ocupada con las niñas. Yes, yes.
I'm busy with the girls.
Y le pegaste en mi. Yes, okay. It's okay, mama.
Okay, Ms. Mancha, do you understand English?
Yes, I understand English.
Okay, would you like to proceed in?
I'm sorry, I have my granddaughters with me. I didn't even know that today would be the divorce. Yeah, because they don't tell me like one day before. Yes.
Okay, so do you want to proceed in English then?
Well, because Juan wants to hear, so we can proceed in Spanish.
Okay. So just make sure that I'm going to allow my translator to translate and don't answer until she has completed the question, okay? First,
Okay.
let me have you and Mr. Mancha Guerra raise your right hands.
Por favor, levante su mano derecha.
Do you swear that the testimony, Ms. Mancha, you need to raise your right hand?
Yeah, Mama.
Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Ms. Mancha?
Yes.
Mr. Mancha jura que el testimonio que está a punto de dar es la verdad, toda la verdad y nada más que la verdad.
Yes.
No, Mr. Mancha Guerra.
Oh. Let me call him. He was here a few minutes ago. So.
Hold on.
Mr. Mancha, ¿me escucha?
Sí, la escucho. ¿Me escucha usted?
Okay.
¿Jura que el testimonio que está a punto de dar es la verdad, toda la verdad?
Sí, lo juro.
Yes, I swear.
Okay. Ms. Mancha, he is present?
Yes.
Okay, so Ms. Mancha, you are the one that filed for divorce, is that correct?
Yes.
And you and Mr. Mancha do not have any children together, is that correct? Ms. Mancha, do you and Mr. Mancha Guerra have any children together?
No, we don't have any children together.
Okay. Now, you and your husband were married on July 29th, 2016 and stopped living together on December 1st, 2020. Is that correct?
Correct.
And you were a resident of Hidalgo County for 90 days and of Texas for 6 months when you filed for divorce. Is that correct?
That's correct.
Okay.
Yes.
Do you all have any debts together?
No.
Do you have any community property together? Ma'am, do you have any community property together? Ms. Mancha,
No, we don't have any property together.
you need to pay attention or I'm going to dismiss you all.
I am paying attention. I don't know what's wrong with my phone. I can even see the video now.
Okay, so the Jeep Liberty, was that purchased during the marriage or before?
During the marriage.
And who's staying with that vehicle?
I'm.
Ms. Castaneda, please ask Mr. Mancha Guerra that, just to acknowledge that him and Ms. Mancha do not have any children together.
Mr. Guerra, por favor, nada más me acuerdo que usted y la señora no tienen niños juntos.
No, no tenemos.
No.
Okay, and ask him if, do they have any community property together?
¿Y no tuvieron propiedad en común?
No.
No.
And did they have any debts together?
¿Tienen deudas juntos?
No.
No.
Okay. So, and is he in agreement to allow her to stay with the Jeep Liberty?
¿Y usted está de acuerdo que ella se quede con el Jeep Liberty?
Sí.
Yes.
And ask him if he recalls signing the divorce decree.
¿Y recuerda usted haber firmado el decreto final?
Sí.
Yes.
Okay. And is he asking the court to accept that agreement and sign that divorce decree?
¿Y ha estado usted pidiéndole a la corte que firme este decreto de divorcio?
Sí.
Yes.
Okay. Then the court will accept the agreement as testified into their record and will pronounce the parties divorced. And I'll ask for the divorce decree that was filed on July 20th, 2021 to be forwarded to my queue. Let him know that they are not divorced until I sign that decree.
Okay. Mr. Mancha, dispense, Mr. Guerra, no está divorciado hasta que la juez firma el decreto.
And just let him know that I'm requesting that today, so it should be soon.
Lo voy a pedir que me lo manden a hoy, so va a ser pronto, pero hasta que no esté firmado no está divorciado.
Ok, y yo cómo estaré enterado cuando ya quede.
And how will I know?
He provided an email address on the divorce decree, so the clerk's office will usually email it to that email.
Okay, usted puso un email, una dirección de correo electrónico en el divorcio, so cuando ya esté firmado, los clerks le van a mandar avisar.
Ok, gracias.
Okay, thank you.
Okay, let Ms. Mancha know that they can both retreat.
Okay, ya se pueden retirar.
Gracias. Hasta luego.
Okay, Mr. Juarez and Ms. Soto, F5576-19-9 in the matter of the marriage of Susie Soto and Osvaldo Juarez.
Yes, ma'am.
Okay, and is Mr. Juarez still on?
Let me see. He is. I think he's having trouble turning on his video and mic.
Okay, and are you still representing yourself?
Yes. I am. Yes, Your Honor.
Okay, Mr. Juarez, can you hear me?
Yes. Yes.
Okay.
Yes, Your Honor.
All right, let me just pull up your case.
May you hear me?
Yes, sir.
Okay.
Okay, so both of you have already signed the divorce decree, is that correct?
Yes, we have, Your Honor.
Okay.
Yes.
Let me go ahead and have both of you raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Ms. Soto?
Yes, Your Honor.
And Mr. Juarez?
Yes.
Okay, you may lower your hand. Ms. Soto, please state your full and correct name for the record.
Susie Ann Soto?
And Ms. Soto, at the time that you filed for divorce, you lived in Hidalgo County for at least 90 days and in the state of Texas for at least 6 months. Is that correct, ma'am?
Yes, Your Honor.
And you are currently married to Osvaldo Francisco Juarez. Is that correct?
Yes, Your Honor.
And you and Mr. Juarez were married on August 7th, 2016 and ceased to live together as husband and wife on October 30th, 2019. Is that correct?
Yes.
And you and your husband have 2 children, Jose Maria Juarez and Osvaldo Juarez?
That's correct.
Okay. And you are currently not expecting a child at this time, is that correct?
That's correct.
And you are asking for a divorce today because your marriage has become insupportable because of discord or conflicts of personalities between yourself and your husband, is that correct?
Yes, Your Honor.
And is there any chance of you and your husband reconciling at this time?
No, Your Honor.
And there is no protective order, is that correct?
No.
Okay. So then are you asking the court, you already have Soto, so there's no need for a name change, is that correct?
That's correct.
All right. The only, let me see, let me check your divorce decree.
Okay.
Okay, and Mr. Juarez will be staying with the 2012 Yamaha R1, is that correct?
Yes, that's correct.
And he will also be staying with the home at 824 East Daffodil?
Yes, that's correct. That's his property that he had acquired before we got married. So we're just stating that, we're not fighting for any property that belongs to him.
Okay, and did you all have any property together while you were married?
No, Your Honor, we didn't.
Okay, all right. And so you each will be responsible for any debts that were incurred solely by you and under your name, is that correct?
That's correct.
Okay. The only thing that I'm not seeing, but I'm gonna double check. Is with respect to your children, I don't see any orders as to visitation or child support.
We already have something established with the Attorney General. There is already a child support that he pays to me monthly and also visitation set.
Okay.
It
What's
should
the
be
cost number on that?
the cost number. Give me one moment. The way it's listed with Attorney General.
Yes,
or
it
with
should
the
start with an F.
Yes, one moment. Give me a quick moment. I should have it here. F-2481-18-1.
Okay. So there's 2 things that need to happen for this divorce to go forward. One, I'm gonna ask my staff to send an order of transferring that case into my court because that's in another court. And number 2, you are required to file a motion to consolidate. And on the motion to consolidate, you have to consolidate this case number into the divorce so that I can honor the agreement as to the child support and visitation. And then on your divorce decree, you see on page 2 of your divorce decree, there's a section that says the court finds that a separate final court order for conservatorship and support of the children was made in, and you're gonna put in Hidalgo County, Texas, and the cost number. Then you have to attach that order that you have and file it as an exhibit. So you have to refile your divorce decree with that order as an exhibit. And that's the one that I would sign.
Okay.
So, and the motion to consolidate, I can't tell you where to find it. You need to do that on your own since you're pro se. But I'm gonna give you some time to do that. Now, you've already proved up the agreement. There are just some technical issues that you need to do in order for me to sign off on that decree. Okay? So I'm gonna give you some time to figure out, I don't know if you're gonna get advice or what, to see how you're gonna do that motion to consolidate. So that motion to consolidate has to be filed before I can sign off on your decree, okay?
Okay.
The next, go ahead.
Will I still have to schedule another hearing?
Unfortunately, yes. Because your motion to consolidate is gonna have an order setting hearing with it. And on your order setting hearing, you're gonna put November 15th at 9:30. But Mr. Juarez does not need to appear because you all have already put this on the record. I just need to ask him a couple of questions right now, and then he'll be fine. He'll still get notice. Both of you would still need to get notice. So, Mr. Juarez, you've heard the agreement that Ms. Soto has put on the record. Is that your understanding of the agreement?
Yes.
And you're asking the court to accept the order that the AG's office has already established in cause number F-2481-18-1, sir?
Is that the divorce?
That's the one that has the child support and the visitation.
Yes.
Okay. So I just need to have that motion to consolidate on file. The order setting hearing will have November 15th on it.
Okay.
Okay? And that's the most that I can tell you, ma'am.
Okay.
It'll be November 15th at 9:30.
Okay, got it.
All right.
No.
That'll be all for today.
Okay, thank you.
Okay, thank you. You all are excused. Okay, number 23 on the docket. Did anyone call in on that?
No, Judge.
Okay. I'm gonna consider that a moot point then. And then number 26, emails were not provided?
No, Judge, the emails on the order setting hearing and the petition were not provided. It was just the address.
Okay, and number 54?
On number 54, Your Honor, Ms. Andrade did check in with the court this morning. I advised her to log in at 11, but I'm not sure if I saw her ever.
Oh, wow. Okay. Well, let's contact their office and see. I see that she hired counsel. So I'm not sure if they, what the situation is, but if somebody can contact them and ask them, if not, we'll reset them for November the 10th.
Yes, ma'am.
Okay. All right, that concludes this morning's docket. And